Yes.
May I please, Your Lordship? My lord, I beg to mention item number 45, 46 for extension of time. Your Lordship, may kindly be taken over at 2 p.m.
We'll take up
Your Lordship.
not 2 p.m. Not 2 p.m. We'll take up.
At 2 p.m.
May please, Lordship, with the consent of the other side, Madam, I beg to mention item number 25, Madam. Here, 2 weeks time may be given to file our affidavit in opposition, Madam.
Yes, who is for the petitioner?
No,
I
I'm
am for the petitioner, Your Lordship.
Okay, Mr. R.K. Mohanty, learned counsel for the petitioner is present. Mr. M. Smith, learned counsel for the respondent number 1 and 2, has sought for and is granted 2 weeks time to file counter affidavit. Any leave the case on so and so. Any interim order?
Yes, Lordship.
Any interim order?
Yes, Lordship.
Okay, interim order. Past it should continue.
1905.
May it be please, Your Lordship.
05, 06.
I beg to mention item number 30 and 31, Lordship. Matter may be
Please.
adjourned for 1 week, Lordship. 30 and 31, Lordship.
30 and 31. Okay, 30. On the request of Miss
Say Khalifa.
S.A. Khalifa, learned counsel for the petitioner. This is possible for the day. It is Miss, who is there? A. Authorised, learned standing counsel revenue department, Miss M. Borman, learned junior government advocate for the state respondents are present. Same. 31.
May please, Your Lordship. Item number 27 may be adjourned for the day. 27.
27.
7.
advance adjournment given, Madam. Advance adjournment.
Okay. Miss A. Borman, learned counsel appearing for the petitioner. Adjournment for what time?
2 weeks, Lordship.
Sought for an adjournment of the case for 2 weeks. Also, it is submitted to Mr. S. Bora, learned standing counsel, GMC. Mr. A. Authorised, learned standing counsel, revenue department are present. Post of it is further submitted that consent has been taken from the learned counsel for the respondents to make the parent, and the mentioned note to that effect has also been circulated yesterday. In view of the above, raise the case after 2 weeks on a date to be fixed by the office.
Lordship, I beg to mention for listing for withdrew.
Withdrawal.
Please, Lordship. Lordship, I beg to mention item number 35. Lordship, one additional affidavit has been filed. Kindly allow to bring the same on record. Lordship.
May I please, Your Lordship, Lordship, I beg to mention for listing of one WPC, Lordship, relating to fishery settlement, Lordship.
Fishery, Bansport.
Daily list for motion. Item 1.
May I please, Your Lordship.
Yes.
Lordship, in this case, Lordship, we have challenged the search and seizure which has been made against me on the basis of a warrant of authorization, Lordship. Lordship will kindly see that the warrant of authorization which has been given to for the search and seizure is at annexure 1, page 40.
The case was adjourned for many times.
Lordship, this was
So
adjourned
in the
because
meantime, I had occasion to go through it.
yes, Your
Come
Lordship.
to the appeal,
Yes, Your Lordship.
appellate order.
Yes,
To
Your
cut
Lordship.
the matter short.
Yes, Your Lordship. The final IT order.
69.
Lordship, that is why, Lordship, what I had done, Lordship, I know that it has been remanded back to the CIT appeals.
Yes.
But Lordship, the appellate, my only grievance in this case is that the income tax appellate tribunal has refused to whatever the we have done. We have challenged this search and seizure on the basis of an unauthorized warrant of authorization because it has been issued by
Let it consider. It has not considered yet.
I want that.
Give the act. Give the act.
This is what I want from your Lordship. Lordship,
Give
this
the-
is what I want. No,
Give
Lordship,
the-
the CIT appeals have already dismissed my petition, Lordship. That is why I wanted both the
Give the
petitions to come
income tax
together.
act. Give the income tax act.
Lordship, the CIT appeals has already dismissed my Lordship appeal.
Where
and
it is
that by
pending
that-
now, madam? Where it is pending now?
Lordship, I have already filed a writ petition against that said CIT appeals order, and that is pending before your honorable court. Lordship,
Come to page 16(9).
yes, Lordship.
Let us read it totally.
Yes, your Lordship. Lordship, this appeal is filed by the SSC against the order of the Commissioner of Income Tax Appeals, Central NER Gauhati, dated 24/1/2024, passed under Section 250 of the Income Tax Act and pertains to the assessment year 2020-21. The grounds of appeal of the SSC are as under. Lordship, there are 3 grounds which has been mentioned, but Lordship, Lordship, for the timing, if your Lordship will see
Let
page
us
67,
read it. Let us read it, madam.
Lordship,
Because it has been listed so many times,
yes, your
I
Lordship.
had to go through it time and again. Now
Because
I have
Lordship,
been.
last time I had mentioned that
I am
this
clear
matter
in
may
my
come
mind.
up along
Let
with
us read it. Let us read it. What is the harm in reading it?
No,
What is
your
the
Lordship, there
harm
is
in
no harm.
reading it?
No
Madam?
harm, Lordship.
Let us
Lordship.
read it.
Lordship, the facts of the case
Yes.
are that a search under Section 132 of the Act was conducted on Medicos Group on 8/1/2021. In the course of search, warrant of authorization under Section so-and-so of the Act was executed on Messrs. Mednomic Healthcare at so-and-so 1/2021. The SSC filed its original return of income under Section 139 of the Act for the assessment year 2021 on 7/10/2020, disclosing nil income. In view of the drawing of Panchanama, notice under Section 153 of the Act was issued to the SSC for the assessment year 15/16 to 2021. And notice under Section 143(2) of the Act was issued to the SSC on the return of income furnished for assessment year 2020-21 being the assessment year relevant to the previous year in which the search was conducted. In compliance to the notice under Section 153A, the SSC furnished its return of income disclosing nil income. The return of income filed under Section 153A was selected for scrutiny by issue of notice under Section of the Act. Notice under Section 142(1) was issued to the SSC calling for details as mentioned therein and placed on record. The SSC furnished details as called for. The same are examined and placed on record. On examination of page number 1 of incriminating seized documents marked as so-and-so, it is observed that it contains certain transactions relating to receipt of money by the SSC company, otherwise than by account pay checks. Further examination of picture extracted from incriminating hard disk marked as so-and-so seized during the course of search and seizure operation at the residence of so-and-so director of the SSC company and key person of the group. The SSC company had received a sum of rupees 11,15,000 from the allottee, namely Dr. So-and-so and so-and-so in the instant previous year on account of premium share investment. On examination of transactions recorded in the seized documents with the regular books of SSC, it is observed that though the transactions through checks were found to be recorded in the regular books, but the sum of so-and-so received on account of premium or share investment was not found to be recorded in the regular accounts of the SSC company. The SSC was asked to explain the transactions recorded in the seized documents. In response, the SSC wider written statement that some claim that the transactions recorded in the seized material marked as so-and-so has no connection with actual project cost of the SSC. The SSC company, number one, the SSC company has not started its commercial operation till date, and the SSC company has not received any premium either by cash or kind from so-and-so and so-and-so. It is observed from the records that the instant previous year, the SSC company had allotted total of 40,000 shares to both the persons. It is also observed that the bank transaction recorded in the picture extracted from the seized hard disk marked as so-and-so of receiving rupees so-and-so on account of investment in share through checks was found to be reflected in the regular books of account of the SSC company. However, in regard to the amount received on account of premium share investment reflected in the documents, the SSC company simply denied such transactions without disproving the facts emerging from the transactions recorded in the impounding documents. The learned AO further observed that the SSC has never denied the transaction done through banking channel recorded in the incriminating documents, whereas the cash receipts recorded in the same documents against the same person receipt of premium share investment, the SSC company denied such receipts. The learned AO did not convince on the claims of the SSC and had made an addition of rupees 11,65,000 to the total income of the SSC by treating as income of SSC within the meaning of 69A of the Act, and also charged to tax under section so and so of the Act.
So this is,
Aggrieved by
this was adverse to you. This was
This was
adverse to,
adverse to me.
this was adverse to you, madam.
Yes,
Okay.
Your Lordship.
Let us read further.
Aggrieved, the SSC company filed the first appeal before the learned CIT appeals. However, the learned CIT appeals, wide order dated 24/1/2024, dismissed the appeal of the SSC. The relevant observations of the learned CIT appeals are as under. During the appellant proceedings, notice under section so and so was issued to the SSC by this office on various dates. There was no compliance to any of the notices issued. The cash received from the two above mentioned parties remains unaccounted in the books, and no satisfactory explanation was furnished regarding the share investment. The AO was right in treating the amount and explained unexplained money within the meaning of provisions of so and so Act and charged to tax under section so and so. Thus, the addition of rupees 11,65,000 made in the assessment order is hereby confirmed. Aggrieved, the SSC filed the present appeal before the tribunal. Before us, the SSC retreated with stand as was taken before the learned AO. We observed that the SSC did not participate in the appellate proceedings before the learned CIT appeals. The learned CIT appeals issued 5 notices under section 250 of the Act. However, the SSC failed to respond to that notices. The order of the learned CIT appeals is an ex parte order. Since the SSC did not participate in the appeal proceedings before the learned CIT appeals, despite issuance of 5 notices by the learned CIT appeals, it is our considered opinion that the SSC should substantiate its claim before the learned CIT appeals. It is also the claim of the SSC that due to the health issue of the key person, SSC could not attend before the CIT appeals. We observed that the SSC failed to substantiate its claim before the learned CIT appeals. The learned CIT appeals constrained to pass the order in absence of the SSC. Therefore, it is our considered opinion that the SSC should get another opportunity to substantiate its claim before the learned CIT appeals. The learned DR also agreed to our opinion for giving the SSC another opportunity to prove their claims before the learned CIT appeals. Discussions, we set aside the order of the learned CIT appeals dated so and so and remand the case of the SSC to the learned CIT appeals. We direct the learned CIT appeals to pass fresh order after giving the SSC an adequate opportunity of being heard. Thus, we allow the appeal of the SSC for statistical purposes only.
Now,
the
let us
result, the
come to
appeal-
your memo of appeal.
Yes, Your Lordship.
Is there any memo of appeal?
Lordship, if your Lordship will see the additional ground, my main case was that not because I have not come on merits before this honorable court. I am not on merits.
Where is your memo of
Because
appeal? I am coming to that. I have,
Yes, Your Lordship.
because of your number of adjournments, I have to read it many times.
Lordship, I just
Come to
wanted
the first, come to the order in original, page 57.
Lordship, appeal memo.
That is
Lordship
the
has
order.
paid-
That is the order, perhaps, order in appeal, page 57.
Lords,
What is this
Lordship,
order,
page
right?
57.
Lords,
And
Lordship, page 67 is one.
where is
the
your
page-
additional grounds, sir, madam?
Yes, Your Lordship,
Where
page
is your
67.
additional ground? Where is your
Additional ground, Lordship, may kindly see at page 67. That is my
page
only
60
submission.
six.
Lordship,
So appeal is pending as on that before Commissioner of Income Tax.
No, Lordship, the Commissioner of Income Tax Appeals have dismissed my appeal and I want to go before the tribunal, and that is why I have challenged both these cases before your
No,
Lordship.
madam.
Only one direction,
Madam, please. After this order,
Yes,
page
Your Lordship.
69,
Yes, Your Lordship.
matter stands remanded to the Commissioner of Income Tax Appeals.
Yes,
Am I
Your Lordship.
correct? Am I correct or wrong?
No, Your Lordship.
Page 73.
Lordship
page
is absolutely
70.
correct. Absolutely correct.
So thereafter, after the remand, any order has been passed by the Commissioner of Appeals.
Lordship, the CIT appeals has dismissed my case ex parte again. This time, Lordship, without issuing me any notice.
Then you go for appeal before the
Lordship, Lordship, I have filed the
income.
petition
Don't
before the-
try, once you have approached the
Yes, Your
Commissioner
Lordship.
of Appeals,
Yes,
right?
Your Lordship.
and
Your
thereafter
Lordship.
agree by the dismissal of Commissioner of Appeal order,
Hmm.
you have approached the tribunal.
Yes, Your Lordship.
Tribunal remanded back the matter. Now you are saying Commissioner of Appeal has again dismissed your writ petition, which is
Yes,
not part of the record now,
Yes, Your Lordship.
right?
Lordship, I have already filed the petition. Last time Your Lordship had ordered that both the writ petition may be tagged together and
Which
come.
writ
Today,
petition?
Lordship, the other writ petition challenging the CIT appeals order. My only grievance is that.
No. When a appellate tribunal is available,
Yes, Your Lordship.
why writ petition is to be entertained? And plus,
Your Lordship. Yes, Your
madam,
Lordship. That's the
madam,
question.
if madam,
Yes.
come to page section 250.
Yes, Your Lordship.
If you have hesitated new grounds,
Yes,
then
Your Lordship.
subsection 5,
Yes, Your Lordship.
that has to be under subsection 5, the Commissioner of Appeals has to consider it. If he has not considered it,
Yes,
he
Your
does
Lordship.
not
That is my only grievance.
go for appellate tribunal.
Lordship,
I am only
not-
thinking why this writ petition should not be held to be misconceived and why it should not be dismissed with cost.
No, Your Lordship. Lordship,
Ah.
this is my only grievance, Lordship, because I have not
Your
challenged
grievance,
this-
you hesitate before appellate tribunal.
Lordship, this is
250 is clear. If that commissioner, madam, who is your other writ petition?
Lordship, the writ petition is not there. I have already filed it. Lordship, this has not come. Last time Your Lordship had directed both the petition to
No,
club
I have not
together and-
directed. I have not directed anything, madam. I am
Lordship,
clear in my orders. I have not
That-
directed anything.
Lordship, that was
Yes,
my
Mr.
request. that
Gogoi.
both the petitions
Yes,
come together.
I have received instruction, Your Lordship.
What instruction?
In last occasion, dishonorable.
Whether this repetition is maintainable or not?
Maintainable. Not maintainable, Your Lordship. The-
Why
Lordship,
you
my
should
only-
entertain this?
Yes. That cannot be.
Lordship,
The grounds which have been mentioned in the
Lordship,
five
I
issues.
Lordship, may kindly hear.
This order, if that Commissioner of Appeal in the impugn order, which is not part of record, has not considered your additional grounds, that is a ground for appeal before the appellate tribunal.
I-
Don't open a second front by way of writ petition.
I don't want, Lordship, if Your Lordship will kindly listen to me, only one. That is my grievance
I
in
am
this case. Only
firm
grievance.
in my view. If you have any ground of grievance,
I don't want any order on merits from this court. Lordship, I don't want any order on merits. My only
absolutely
grievance
not.
is that the
Not
tribunal-
required. We are not required when the appellate
Lordship,
mechanism,
this is what-
machinery
This is
set
the
up by Income Tax Act are in place, where all these grounds regarding alleged authorization, source authorization, can be a ground to be hesitated. That is not a ground to be hesitated in a writ petition. Heard, Miss Anne Howelia.
Lordship, I have not challenged anything in this petition. Lordship, I have not come on merits. Lordship will kindly see that I have
And
not challenged this on merits.
madam, I am on the procedure. I am not
Lordship, I
entering
am
into
also on
merit.
the procedure. Let
The
me
more you
only-
agitate,
only
the cost will be more.
On this issue, Lordship,
Hard.
only one judgment of the division bench on the same issue, which says that if search and seizure cannot, Lordship, my only grievance is that the tribunal is not considering my prayer.
Why
of
it
search
is
and seizure.
not, I am only on the question why it is not to be held as misconceived. Hard.
Lordship, because I have not challenged the case on merits. I have only
Absolutely, I
said the
know.
tribunal may be-
I am 100%
Tribunal
clear,
may be-
madam. I am 100% clear that you are not on merit.
No, Lordship. So if
You are
Lordship,
opening
if
a
I'm not on
second
merit-
front by way of a writ petition. You are
No,
hell
Lordship,
bent
I'm
up
not opening a second front.
hard,
No,
Miss
Lordship.
Anne
No.
Howelia,
Lordship,
London
Kindly see-
Council for
kindly
the
listen to-
petitioner.
Kindly listen to me.
Mr.
I only want to
I have
correct-
given you 20
Lordship,
minutes time. I am not satisfied at all, and I'm not going to be satisfied at all.
Lordship, only
This is
only one
abuse,
thing I will
basically
just
abuse
note,
of
and
the
that may be
process of the court.
My Lordship, my this prayer may be dismissed. My submission may be dismissed, but my submission is only one thing. I don't want an adjudication on merits on this case. I just want that the tribunal may hear my search my prayer for search is that I
If
want to
the,
challenge.
if the commissioner and appeal
Hmm.
has dismissed your appeal without any reason, then you can prefer the appeal before the appellate tribunal, where you can hesitate that search authorization was illegal, and you hesitated it as an additional ground under subsection 5 of section 50, 250, then it is a good ground for your appeal, not in a writ petition.
Lordship, that may kindly be recorded, that the tribunal may consider. That is the only thing I want, Lordship.
I will say that is a good ground for appeal.
Lord, that's a good ground
I have
for
not
appeal.
seen, I have not seen the Commissioner of Appeals order. That is not part of this writ petition.
I filed the petition.
You have verbally said, heard.
Lordship, that is what I have prayed, Lordship. That is my
But
matter.
madam, don't interrupt.
Matters may be dismissed together with the observation that the matter may be filed before ITAT and he may consider all my. That is my only prayer, Lordship. He may consider my prayers. They are not considering my
Madam,
prayers.
this writ petition is only against the search authorization and after the remand. So
Yes, sir, only
I'll
that.
take
Only
note of
that.
your, I'll take note of your verbal submission and
Yes, Your Lordship.
observe accordingly, madam.
Yes, Your Lordship. That
Please
is my only
don't try
concern.
to interrupt the proceeding. I have already indicated that if it is a ground which was
Yes, Your Lordship.
which was hesitated before the Commissioner of Appeals as an additional ground, and if that ground was not taken, then the SSC before that appellate tribunal can hesitate that ground. It would be open for
Yes,
him
Your Lordship. Much
under
obliged, much
subsection
obliged.
5.
Yes, Your
So
Lordship.
why
That
you
is
are
my.
wasting your time for last half an hour?
So sorry, Lordship. Lordship, I
This
thought,
is
Lordship.
otherwise this is completely a misconceived writ petition. Yes, you have anything to say?
No, Lordship. This petition is not maintained.
Dr. B.N. Gogoi, Learned Standing Counsel, Income Tax Department, for all the respondents.
Lordship.
Full stop. Para. The petition has sought to invoke the extraordinary and discretionary jurisdiction under Article 226 of the Constitution of India. Alleging that the warrant of authorization issued under subsection 1 of section 132A of the Income Tax Act 1961 in form number 45C, issued by the additional stroke Joint Commissioner of Income Tax on 8/1/2020,
Twenty-one, Lordship.
8/1/2021 was without jurisdiction and invalid. Full stop. Para. From the materials on record, next to the writ petition, it has emerged that A search under section 132 of the IT Act was conducted in the premises of the petitioner on 8/1/2021. In the course of such search, warrant of authorization under section 132 within bracket 1 of the Act was executed on the petitioner on 8/1/2021 and a punch-number was drawn on 9/1/2021. Full stop. But subsequently, pursuant to a notice of demand under section 156 of notice of demand dated 25/3/2022 for the assessment year 2020-2021 under section 156 of the Income Tax Act 1961 and a further notice under section 274 read with section 271 AAC within bracket 1 of the Income Tax Act, an order dated 24/1/2024 came to be passed under section 250 of the Act. Repealing the contention of the petitioner SSC. Oh, sorry. What is the original order?
Lordship, the 25/3/2022.
What is the original order?
Lordship, page 49 is the 25/3/2022 order. Page 49.
Okay, an assessment order. An assessment order under section 153A/143(3), read with section 153D of the Act, came to be passed by the assessing officer. First of it was in the assessment order, it was observed that in the previous year, the petitioner SSC had received a case amount of rupees 11,65,000 on account of quote unquote premium share investment unquote, which had remained unaccounted in the regular books of the SSC as well as unexplained. Full stop. As such, a sum of rupees 11,65,000 therefore, the sum of rupees 11,65,000 was treated as income of the petitioner SSC within the meaning of section 69A of the Act for the previous year and charged to tax under section 115 BBE of the Act. Full stop. Penalty proceeding under section 271 AAC of the Act has also been initiated separately. Full stop. In the assessment order, the assessing officer has assessed the petitioner SSC, under section 153A/143 within bracket 3, read with section 153D of the Act. Full stop. Para. It has further emerged that agreed by the assessment order, the petitioner SSC preferred an appeal before the Commissioner of Income Tax Appeals. Full stop. The Commissioner of Income Tax, within bracket appeals, within bracket CIT, within bracket A, dismissed the appeal of the petition SSC by an order dated 24/1/2024. Full stop. In the appellate order, comma, the CIT, the appellate authority corridor. CIT like the appellate authority for short. Observe that during the appellate proceedings, notice under section 250 of the IT Act was issued to the petitioner SSC on five different dates, but there was no response to the notice issued. Full stop. In view of non-representation of the petitioner SSC before the appellate authority, the appellate authority had observed that the case received from the parties, from the two parties, mentioned in the assessment order, by the petitioner SSC remained unaccounted in the books and no satisfactory explanation was furnished regarding the share investment. Full stop. The appellate authority agreed with the finding of the assessment officer in treating the amount as an unexplained money within the meaning of the provisions of section 69A of the IT Act 1961, really Act 1961, and charged to tax under section 115 BBE of the Act. Full stop. The appellate authority had thereby confirmed the addition of rupees 11,65,000 made in the assessment order. Full stop. Aggrieved by and dissatisfied with the appellate order dated 24/1/2024, the petitioner SSC preferred an appeal before the Income Tax Appellate Tribunal, the Appellate Tribunal. Full stop. Which was registered as ITA number 56/ZTY/2024. Full stop. Before the tribunal, the petitioner SSC hesitated that it could not participate in the appellate proceedings before the appellate authority, despite issuance of 5 notices due to health issues of the key person and poster. The appellate tribunal took notice of the fact that the petitioner SSC did not participate in the appellate proceeding before, despite issuance of 5 notices. As a result, the order passed by the appellate authority had become was passed in an ex parte proceeding. Post op. The appellate tribunal had thereafter proceeded to observe that as the petitioner assessee failed to substantiate its claim before the appellate authority, and in view of non-representation of the petitioner assessee before the appellate authority was constrained to pass the order dated order on 24/1/2024 in absence of the assessee, the petitioner assessee should get another opportunity to substantiate its claim before the appellate authority. Full stop. The view expressed by the appellate tribunal was agreed upon by the learned defense. This is DR means defense representative,
Lordship.
by the learned DR, that the petition assessee should get another opportunity to prove its claim before the appellate authority. Full stop. Para. Observing so, the appellate tribunal set aside the order dated 24/1/2024 passed by the appellate authority, and by an order dated 7/3/2025, had remanded the case back to the appellate authority with a direction to the appellate authority to pass a fresh order after giving the petition assessee an adequate opportunity of being heard. Full stop. Para. In this writ petition, the petitioner has projected that the impugned search and seizure proceeding conducted on 8/1/2021 by the respondent number 2 and all actions taken in consequence thereof should be set aside and quashed. And has sought for a direction not to initiate any proceeding in connection with the impugned search and seizure dated 8/1/2021. Full stop. Para. It is after the search proceeding conducted on 8/1/2021. The subsequent proceedings were drawn up against the petitioner assessee under various provisions of the Act. Full stop. The petitioner assessee responded to the notice issued by the assessment officer by filing a reply. So it was thereafter, the assessment order dated 25/3/2022 came to be passed by the assessment officer. Full stop. Thereafter, the petition SSC had preferred an appeal before the appellate authority. But after filing the appeal, the petitioner SSC did not participate in the proceeding despite issuance of 5 notices for its appearance in the appellate proceeding. Full stop. In view of non-representation of the petitioner SSC before the appellate authority, the appellate authority had passed the order on 24/1/2024 ex parte. Full stop. Whereas the appellate tribunal has, however, interfered with the order dated 24/1/2024 by an order dated 29/2/2025, and has observed that while remanding back the appeal to the appellate authority, and has observed that the appellate authority shall pass a fresh order after giving the petitioner SSC an adequate opportunity being heard. Full stop. Para. The petitioner, the learned counsel for the petitioner SSC has sought. Full stop. Para. At the time of filing the instant writ petition, the appellate authority was in seizing of the matter, seizing of the appeal, and no appellate order was passed. Full stop. It is the contention of the petitioner that before the appellate authority, after filing the appeal, the petitioner SSC had also submitted additional grounds. Where are those additional grounds?
Page 67, Lordship.
Page
67.
57 is the order. Where is
67,
your
Lordship.
additional ground?
67, Lordship, 67.
67. When did you file it?
Lordship, the date is, Lordship,
Additional ground.
yes, sir.
And with an apprehension that the additional ground would not be considered by the appellate authority, the petitioner has approached this court by the instant petition. Would not be considered. And it is an apprehension of the petitioner SSC that those additional grounds would not be considered by the appellate authority while disposing of the appeal of the petitioner SSC. First of subsection 5 of section 250 of the Income Tax Act 1961 has prescribed that has provided that the appellate authority may, at the hearing of an appeal, allow the appellant to go into any ground of appeal not specified in the grounds of appeal, comma, if the appellate authority is satisfied that the omission of that ground from the form of appeal was not willful or unreasonable. First. As the appellate, as at the time of preparing the writ petition, the appellate authority was seizing of the appeal and with the additional grounds filed by the petitioner on record, comma, the apprehension expressed by the petitioner SSC that those grounds, additional grounds, would not be considered by the appellate authority is clearly premature and misconceived one, first off. And in such view of the matter, comma, this writ petition is found to be misconceived one. First off, when an appeal is pending before the appellate authority, and the appellate authority is still saying of the appeal, comma, the petitioner, by preparing the writ petition, has sought to append a second ground of assail, a second front of assail, comma, which is not permissible. Full stop. Para. During the course of hearing, comma, the learned counsel for the petitioner has submitted that during the pendency of the writ petition, comma, the appellate authority has already passed an order dismissing the appeal of the petitioner SSC. Is it right?
Yes, Your Lordship.
Is it right?
Yes, Your
And,
Lordship.
and what is the ground?
Lordship, no, ex parte. It has been passed ex parte
Ah.
without giving any notice.
And the appellate order is again an ex parte order. Full stop. And the additional grounds is filed by the petitioner
Has
was not considered, has not been considered. Full
Yes, Your
stop.
Lordship.
If such is the contention of the petitioner SSC, that the appellate authority has again passed an ex parte order without issuing any notice to the petitioner SSC, and the additional grounds filed by the petitioner before the appellate authority has not been considered by the appellate authority, then it is open for the petitioner to raise all such grounds before the appellate authority in an appeal.
Yes, Your Lordship.
Uh,
Before
in an
Before
appeal, in an appeal which lies under
Section
section
252.
252,
Ah.
252
Yes, Your Lordship.
of the Income Tax
Yeah.
Act.
Much obliged. Much obliged.
Deeply obliged.
Deeply obliged.
Item 2. They have filed affidavit in opposition. My lord. I'm paying for, my lord, 5 days time to file my reply, my lord.
How much time?
5 days only. I have already saw the instructions, they are coming, my lord. Instructions are coming.
Okay. Well, issue notice, make it, say, 9/6.
My lord.
Heard Mr. R.S. Mishra, learned counsel for the petition, Mr. B. Gogoi, H. Bolua, learned counsel on behalf of Mr. B. Gogoi, learned standing counsel, Finance and Taxation Department for all the rest. First of Mr. Mishra, learned the respondents has already filed an affidavit in opposition to the, respondent number 2 has already filed an affidavit in opposition. First of issue notice, returnable. Oh, no, Mr. Mishra, and counsel for the petition has sought for and is granted. Okay, be eligible. Jihul.
Affidavit filed, my lord, or any?
Okay, we'll make it 16
My lord.
so that we can decide.
Yes,
My lord.
otherwise, my lord, as per my instruction in our affidavit, we have issued the show cause.
So good.
Yes, it has been issued. Not only
Under
DRC
section
one.
73.
Yes, ma'am. So cause DRC one always enclosed separately, my lord. It's there in the
Can-
repetition.
You can have the record then.
My lord, it's there in the repetition itself. Let him reply,
Okay.
but it is there in the repetition. I can
Which
show
one? Which one?
you. Page 24.
Okay.
Page 24.
Okay. So, for 2 weeks' time, has prayed for and is granted 2 weeks' time to file an affidavit in reply. Let notice be issued. Notice is made returnable on 16/6/2000. As all the respondents are represented, notice is made returnable on 16/6/2026. The interim order passed earlier shall continue.
Item number 3.
May it please your lordship. My lord, this matter pertains to my lord eviction from my land, my lord.
You're supposed to file an additional affidavit.
Yes, my lord, that has been today itself filed, my lord, but it has not come.
It is not on record. Otherwise, how your right to
My
continue in occupation can be established?
my lord,
Order is at page
Hmm?
22, my lord. The speaking order is at page 22.
22,
Yes, annexure 2, my lord.
Page,
Annexure two-
page?
Sorry, 104, my lord.
104,
Annexure is at annexure number
104,
22.
104. This is the order.
yes, my lord, this, I have challenged this order, my lord. If your lordship, my lord, see the
But
order.
it will justify contention, landless people.
Yes, my lord.
But what was the case about?
My lord,
What is your claim for occupation? What kind of right you have?
my lord, I have filed, my lord, several documents along
Let
with
us
my,
see, let us see.
in my, along with my. additional-
Municipal board received,
Yes, my lord.
page 31.
My lord,
What is for that?
my lord, other than this, my
Sai
lord,
Sampati Kor receipt. You have a holding number.
yes, my lord, if your lordship come to page 37.
Show us
my
your
lord.
land document.
My lord, okay, page 37, my lord.
37.
Yes, it's, my lord, issued by the circle officer, North Lakhimpur Revenue Circle, my lord. Certified to the Gov land measuring 1 katha 10 lesser covered by dag number 704, my lord. Whereas, my lord, along, throughout the, my lord, at page 39, annexure 4, my lord, they have given, my lord, notices under dag number.
This 38, let us read it further. This certificate is issued for obtaining KCC loan
Yes, my lord.
and shall not be used for claiming settlement over the land and for any other purpose.
Yes, my lord, that's correct, my lord.
You cannot
Yes,
now claim
no, only.
on the basis of this certificate. Maybe loan, what is KCC loan?
Yes, yes.
Google it.
This is.
No other purpose. So you cannot derive anything
Yes, sir.
from this document. Now 704. Now what is
Only to show, my lord.
so important with
My
dag
lord,
number
my lord,
704?
We are holding the land under dag number 704. Whereas, my lord, throughout the notices was sent, my lord, at page
Covered
39.
by so and so is presently being
39.
occupied. Occupied means occupied only,
My lord,
not legal occupation.
my lord, I may submit, my lord. Under dag number 704, I am occupied, my lord. But they have given the, my lord, notice as per, my lord, under rule 18(2) at
Where?
page 39, my
Where is
lord.
that?
Page 39, my lord. Annexure 4.
This is to
My lord, schedule-
Manjuara.
Yes.
Now who is this Musa?
He is my husband of my lord.
Huh?
Husband, my lord.
Your husband.
This is the, my lord, dag number 702. Throughout,
Beta Begum, no. Your husband is late Ashraf Ali. Where is Musa? Musa is not. Musafirpur is not there. None of the petitioner is by the name of Musarifur. None of the petition.
Petitioner.
My lord, in the-
Huh?
Petitioner number 6.
6. Monjuara. Okay, Monjuara.
wife of Musarifur Rahman, my lord.
Okay, Monjuara Musarifur. Musarifur. Only these one petitioner. Who are
There-
the
there-
others?
There are, my lord, several, my lord, notices, similar notices, my lord, are in the earlier round of.
Have you stated so?
I have, my lord.
Petitioner
annexed
will to
articles, my
state
lord.
that
Now, my lord, if your lordship, my lord, come to page 81, my lord,
page.
page 81, my lord. This is the third round of litigation, my lord. Page 81, my lord, clarify, my lord. On 19/3/2025, my lord, this honorable court has passed this order, my lord. Para 3, my lord.
Appropriate forum. Sealing the order.
It is at page 81.
Page 80.
81, my lord. 81 is the, my lord, starting of the order dated 19/3/2025, my lord. It's passed in WPC number 6.
Considering the matter of the disposal by the order. Circle officer is that. No, why you have been asked to file an additional affidavit?
My lord, because, my lord, my alternative prayer is that we are the, my lord, landless people.
Ah.
Therefore, as per land policy of 2019, my lord, we are entitled, my lord, some, my lord, alternative accommodation. Therefore, my lord, I have filed.
Let it be on record then.
Yes, ma'am.
Since the court has already asked, and Sarkar Learned Counsel for the petitioner submitted the additional affidavit in reference to the order dated 27/3/2026 has already been filed, and the said additional affidavit is not on record. Mr. Aforesaid, standing counsel revenue for 1 and 2 M. Bormon. 3, 4, 3 and 4 are present. List the case on Wednesday with the additional affidavit, stated to have been filed by the petitioners, on record.
My sir. 3rd June. Item 4. Instructions were sought for.
Lordship, we have received the instructions that the order in original was dispatched through speed post, Lordship, to the petitioner. And also, they
But-
have made a amendment in paragraph number 6 that after Shoko's reply, they have not received any communication. But they
The
are
question is the appellate authority, see appellate authority.
Lordship.
Now, again, Finance Act. Finance Act, right?
Finance.
Whether dispatch will complete. Giving of notice is, or sending the order is one thing,
Lordship.
but here from the date of receipt of the decision or order
From the date of the receipt,
received,
Lordship.
not from the date of passing the order.
Order. That is,
Both are not same.
both are not same.
Now, what is that provision? Section
85.
35C, 37C,
37C, madam.
Central.
Excise
Excise
Act,
Act,
1944.
If you fail,
Lordship.
then there are other modes. I think 37C not only stops at sending the order, service of decision. Any decision order passed shall be served by tendering the decision or sending it by registered post to the person for whom it is intended or authorized, if the decision cannot be served. Now you don't know it has been served because your appellate order,
Lordship,
see, page 87,
Lordship.
9.4.
In this regard, I find that the appellant submission did not speak clearly about the delivery status of the imperial order dated so and so. Let's continue the submissions made by the appellant claiming the receipt of the imperial order by email. Considering the fact that actual delivery of order is only available with the jurisdictional department authorities, the Assistant Commissioner Dibrugarh Division was requested to confirm whether the order was returned undelivered or was duly received by this office letter dated so and so.
Then next,
Lordship
they inquired. Yes, Assistant Commissioner
has confirmed that
submitted a reply. And
Lord-
here he said it was found that tracking information was not available.
Lordships
Moreover, order in original has not returned back.
returned back.
Just because it has not returned back, it cannot be presumed, maybe,
Maybe.
that he has received
Received
it.
it.
And the time period starts from date of receipt.
Correct.
For the timing, we'll examine the matter.
Lordships.
You file your affidavit.
Lordships.
Heard Mr. R.S. Mitchell and counsel for the petition. And Mr. K. Jain, learned counsel on behalf of Mr. S.C. Kyle, learned senior counsel and special counsel.
For respondents 2 to 5, Lordship.
For respondent number 2 to 5. Anybody? Yes, you are CGC, Mr. Mehdi? CGC?
Yes.
Mr. P.K. Mehdi. Yes. Central Government Counsel for the respondent number 1. Post of para. Which order you are agreed by?
Yes,
Is there no appeal against this order?
Lordship. Appeal
Appellate
right.
forum?
Sir, before session, madam.
Before
Okay.
session.
At Kolkata, madam. At Kolkata. Before session at Kolkata.
Yes,
It's an appealable order.
appealable order.
Sir, never served, madam.
Hmm?
Inquiry was conducted at the back of the petitioner. No opportunity hearing was given by the Commissioner of Appeal, madam. There is nothing on the record was served, madam.
Since a point is involved, you can entertain, but otherwise now if there is appellate order, then it should go.
Yes, madam.
The petitioner has approached this court by the instant repetition to assail an order dated 6/8/2025. Order in appeal dated 6/8/2025. Passed by the Commissioner bracket appeals, CGST, Central Excise and Customs, Gauhati, within bracket, the appellate authority for fraud. By the appellate order,
Right.
the appellate authority, appellate authority has what is the order in original?
Yes, 46.
Has
46, madam.
has dismissed the appeal preferred by the petitioner under subsection 3A of section 85 of the Finance Act 1994 on the ground that presentation of the appeal was beyond time. As the presentation of the appeal was beyond time, the appeal was dismissed without going into the merits of the case. First off, it is the contention of the petitioner that the copy of the order in original dated 20/06/2024 was received by the petitioner only on 5/2/2025. And accordingly, the appeal was presented before the appellate authority on 10/3/2025. Full stop. On the other hand, Mr. Join has contended that the appellate authority considered the said aspect in the order in appeal. Full stop. The appellate authority has observed that the order in original was issued on 20/06/2022. And which when it was sent,
It is not mentioned, Lordship.
the same was dispatched through speed post bearing a consignment number, full stop. When the consignment was tracked
Lordship, consignment number is there, but I don't have the date.
on the India Post website, it was found that the tracking information was not available. Full stop. Taking into consideration that the order, the consignment containing the order in original was not returned, the appellate authority reached a view that the normal period of limitation of 2 months expired on 19/8/2024 and the further extended period of limitation of 1 month expired on 19/9/2024. Full stop. As the appeal was presented only on 10/3/2025, the appellate authority has rightly observed that the presentation of appeal was beyond time. Post of para. Mr. Mishra, Land Council for the petition, has submitted that the period of limitation, as per subsection 3A of section 85 is to be calculated from the date of receipt of the order in original, not from the date of sending the order in original, either by registered post or speed post or by any mode of service as prescribed in section 37C of the Central Excise Act 1944, post of as the materials on record do not reveal as to when is the date of communication or receipt of the order in original by the petitioner. The matter would require further consideration. Issue notice returnable on so and so. Next control review. As issue notice, first of as all the respondents are represented, and notices made returnable on so and so. Extra copies having regard to the projection made and considering the fact that there is no finding as regards the date of receipt. No specific finding as regards the date of receipt of the order in original by the petitioner. It is ordered in the interim that there shall not be any coercive action against the petitioner on the basis of the order in origin appeal dated so as till the returnable date.
22nd June. Much obliged. Item 5.
কেইজনৰ ডাউটা লিখি দিলো the order in appeal. An appeal would lie from the order in appeal before the session. Yes. Yes, madam.
Lordship, that appeal has been registered, my lord, on 27/5/2026. Registration number is at in case 2, my lord. And accordingly, hearing is fixed on 4/6/2026, my lord.
Heard Miss.
And follow-up steps that are to be taken, my lord, it is placed in the note, my lord. How they have to track that appeal, my lord.
I have to.
Note is there, my lord,
You appear, Mr. Mohanto, there.
because it's a
Heard Mr. D. Mohanto, learned counsel for the petitioner, Ms. Ann Bordole, learned standing counsel, Revenue Department for the respondent number 1, and Ms. M. Gorman, learned junior government advocate Assam for the respondent number 2. Gustav. The petitioner has approached this court stating that single petitioner, multiple
people,
petitioner.
my lord. Notice is
That
sent.
they have filed an appeal before the respondent number 2 under section 147B of the Assam Land and Revenue Regulation, 1886 on 4/7/2025. Which appeal, despite being registered as application number, লিখা আছে দেই, page 4/5/2026 order to number, has not been heard and disposed of also. Para. Yes, madam. Ms. Borman has submitted comma on instruction, comma, that
Registration. 4/6. Third line, my lord, that date of 4/6/2026 has been fixed at 11 AM for entering appearance and having
the
objections.
date. So any revenue appeal number?
That application is the second line, my lord, RCMS/RAD SAD 2026,
Same
that
thing.
number.
The appeal has already been registered.
Number is different, my lord. Number is different, my lord.
On the same
Application
thing.
number is different and registration number is different.
The same.
This is application number, I
Same.
think. RAD SAD 2026.
And appeal has already been registered and notices have been issued to the parties fixing a date of hearing on 4/6/2026 for their appearance. As the next date of hearing is on 4/6/2025 and the Board of, the appellate authority is in the process of, is proceeding further with the appeal, this petition is closed, permitting, as the petitioners are to appear before the respondent number 2, appellate authority, that is respondent number 2 on 4/6/2026. Look, the documents placed by Ms. Borman is kept to the case.
Obliged.
Give a copy to him.
Lordship.
6. Item number 6.
There is no representation on behalf of the petitioner today on call.
1 and 4, my lord.
Sir M. Das,
Item 6.
Junior Government Advocate, Assam, for the respondent number 1 and 4. is present. Lays the case. After in view of non-representation on behalf of the petition to the call, lays the case after a week on date to be fixed by the office.
Item number 7.
May please lordship, my lord. Here, for the time being, my lord, seeking notice only. I'm just briefing the facts.
Which area? North Gauhati or which area?
Yeah, the Panjabari area.
Oh, Panjabari area. Yes. Respondents.
Just
Revenue. Okay. Go through it. District Commissioner, Public Works Department, ZMDA. ZMDA is appearing, PWD is appearing, Revenue is appearing. All are names are appearing. ZA is not appearing. Okay. Page 33, this is your case.
yes,
This is your case.
yes, my lord.
Okay.
33.
Heard Mr. R.P. Sharma, learned senior counsel, estate by Miss learned counsel for the petitioners. Miss Anne Bordolo, learned standing counsel, Revenue Department for the respond number 1 and 2. Mr. N. Das, M. Borman, learned junior government advocate Assam for the respond number 3. ZMDA, Mr. Gugoi. Okay, Mr. P. Nayak, standing counsel, GMDA for the respond number 4. And Mr. B. Gugoi, standing counsel, Public Works Department for the respondent number 5. Post of para. The petitioners, the two petitioners have claimed that their successors in interest of Srimati Bhadui Lalung, page 33, comma, Srimati Pelani Lalung, and Sri Gadhula Lalung, right? Post of. And they were in occupation. You have been evicted from all these places?
Yes.
Okay. And they were in occupation of the following portions of parcels of land since the time of their predecessors in interest. Land details. Yes, 33 does. Huh? Issue notice returnable on so and so, as so and so is appeared, accepted. No formal notice, extra copies within 2 working days. You are evicted.
Yeah, I am evicted. We are evicted.
The petitioners have stated that from the aforesaid parcels of land, they have been evicted forcefully without compensation.
Without compensation, without even notice, my lord.
Without notice and without compensation.
How will
17 July,
notice?
1707.
Party department, side.
Item number 8.
Yes.
May it please your lordship. Lordship, the matter is related to the petitioner's bank account freezing.
Heard Mr.
Edeka.
A. Dekar, learning counsel for the petition. The petitioner stated that he maintains a savings bank account number so and so at Hatsingmari branch of HDFC Bank. Within bracket respond number 2. Post of. Due to a suspicious on the allegation, no, on the pretext that there has been a disputed transaction to the extent of rupees 5 lakh. The petitioner said savings bank account has been blocked. On receipt of an intimation from Punjab Amritsar Rural Cyber Crime Police Station, response number 3, without any notice either from the bank authorities nor from the investigation authority. Issue notice, returnable on certain steps, speed post. 3 working days.
GA may be required.
Name of, no, you're not there.
No, my lord, reflection is not there. That is why
Huh?
we missed that. Item 7, my lord.
Or name of
I did not make
Learned
that.
Government Advocate, Assam, is to be reflected in the respondent side in the cause list. Ago item 2.
July. Items 9 and 10.
Mr. Bishwas, we'll issue notice so that we can dispose of both. In the meantime, if you are a party in this one, file your reply. Right? We'll issue notice in this case. New case, Mr. I. Chaudhary. So that both can be disposed of. Otherwise, you are not affected as on
I'm
date.
not affected. The only thing was, your lordship, in my case,
But while disposing of your case, this case, your facts are to be recorded, otherwise
Yes.
it will be difficult. Some Boro, Malati Boro raised the issue or something.
Dalimi.
You are, you are, Dalimi.
Yes, yes.
But you have failed.
Yes. Yes, Lord.
You have failed. But Mr. I. Chaudhary, learned counsel for the petitioner, you are not here. Revenue and Bordeloi.
For 1 year.
1. Mr. H. Sharma, learned additional 2 and 3.
Number 10, Lord.
No. Item number 9, we are issuing notice. And we'll fixing this case. We'll be fixing this case along with 10 on a particular date. In 10, already notice has been issued.
In the cause list, our name may be reflected. That is why I am stating that most probably we are not there. That is. So, 2 and 3. In item 9 also 2 and 3.
The petitioners have sought for a direction to the respondent authorities to proceed with the application submitted by them for grant of mutation in respect of a plot of land measuring 1 bigha, 7.27 lesas, covered by DAG number 700 and Pattam number 362 situated Revenue Village, Khanapara, Mauja, Beltola, Kamrup, Metro, Assam. Full stop. It is submitted during the course of hearing that another writ petition, WBC number 6489/2024, is interconnected with the subject matter of this writ petition. Issue notice returnable on after holiday, summer, as Ms. Bordole appeared accepted, and Sharma 2 and 3, no formal notice, extra copies within 2 working days. List the case on so and so along with WBC number 6489/2024.
1707.
Obliged.
Item number 11.
Lordship,
Yes.
Lordship, the matter pertains to Lordship, benefit of PMAY scheme, Lordship.
Art Mr. B.U. Loskar, learned counsel for the petitioner. Miss
And Bora.
N. Bora, learned standing counsel, Panchayat and Rural Development Department for the respondent number 134
134
5 and Mr. Vijay Thalwar, Senior Counsel, listed by Mr. P.K. Medhi, Learned Junior Advocate for the respondent number 2. The petitioners are inhabitants of Nitainagar Gaon Panchayat, District Hailakandi. Post of their names. The petitioners have stated that their names have been included in the list of selected beneficiaries under the Pradhan Mantri Awas Yojana Gramin within bracket PMAY-G for গ্রাম পঞ্চায়েত হেৰি কি কয় নারায়ণপুর টুপকানা গ্রাম পঞ্চায়েত
Earlier it was Narayanpur, Lordship.
Hmm.
After Lordship,
Okay. For inhabitants of village Gongpar Dhunkar, which was earlier within the territorial jurisdiction of Nitainagar
earlier Lordship, it was Narayanpur to
Narayanpur Tukana Gram Panchayat, and after the delimitation exercise, their village presently falls within the territorial jurisdiction of Nitainagar Gram Panchayat. The petitioner have stated that their names have been included in the list of selected beneficiaries of PMAYJ in the year 2021-2022 for despite inclusion of their names in the list of selected beneficiaries for sanction of rupees 1,30,000 each, the petitioners have not been disbursed the same amount despite repeated approaches made by them before the respondent authorities. Issue notice returnable on so-and-so as Ms. Bora and Mr. Medhi. No formal notice, extra copies within 2 working days.
2007. Item number 12.
Lord, on last topic and Lordship, in this case, we have been directed to obtain instructions. I am praying for some more time, Lordship.
Board of Revenue remanded the matter back.
Yes. Telephonically, I had a talk with the ADC Lordship. He told me that make a prayer before Lordship to get some more time.
Basically, he has to comply with the direction.
Lordship. Or if your Lordship desires in by that way, within a period of 2 or 3 months, that can be done.
That can be done because
Yes.
there is a direction of the revenue board
Yes,
which is
Lordship.
to be followed. Just to be
I have
complied
been
with.
told that one date of hearing was there, thereafter by its stalled, Lordship. But even then, if your Lordship directs, that can be done, Lordship.
We can fix a date for hearing, but date of appearance of the petitioner,
Lordship.
so that he can proceed.
Lordship.
Otherwise, Again, he has to issue notice. Will fix a date of appearance of the petitioner. Thereafter, the respondent number 2 will proceed with the matter. I think that will be good enough. Say for within 3 months' time.
Lots.
Today is 29. We can put his date of appearance on 8th of June.
Lordship.
8th of June
8 June.
at 10:30.
My lord, 8 June.
Heard Mr. A.K. Jain, learned counsel for the petitioner. Mr. Revenue.
The revenue is there, right?
Authorized.
Lordship.
Land Standing Counsel, Revenue Department for the respondent number 1, and Mr. H. Sharma, learned
2, 3, and 4.
additional senior government advocate for the respondent number 2 to 4. Agor order to 2E আৰু 3 লিখি দিব। 4. Mr. Sharma, learned additional senior government advocate. Assam, appearing for the respondent number 2, 3, and 4 has submitted that the matter of mutation. The respondent number who is in season of the matter, additional.
Respond number 3.
Has submitted on instruction, comma, that the respondent number 2 is presently in season of the matter of mutation, and a date of hearing was earlier fixed. Full stop. He has submitted that since the respondent number 3 is
The direction was to the ADCLA. To the ADC at page 55.
Page 55. Okay, then respondent number paragraph 2. Third line of 3.
Page 55, paragraph number 8. In view of the above, the appeal is allowed. The matter is remanded back to the learned ADC to re-examine the land records pertaining to.
As I guess order submitted that this petition can be disposed of with a direction to the respondent number 3 to bring the process to its logical conclusion within a reasonable period of time, and according to him, a period of 3 months would be reasonable for the respondent number 3 to pass a final order in the matter of mutation as directed by the Board of Revenue in its order dated 25/3/2025. Post of Mr. Jain, learned counsel for the party. Petitioner has submitted that the petition has no objection if the proceeding is concluded within a period of 3 months with an opportunity for the petitioner. If an opportunity is provided to the petitioner as directed by the Assam Board of Revenue Assam, post of in view of the broad consensus arrived at by the learned counsel for the parties in the aforesaid manner, and considering the fact that the respondent number 3 has been directed to verify whether any conversion to the petitioner's parcel land to government land has occurred, with an opportunity to the petitioner to be heard, comma, this petition is disposed of with a direction to respondent number 3 to bring the process to its logical conclusion after affording an opportunity to the petitioner of being heard, full stop, to bring the process to a logical conclusion, comma, the petitioner is directed to appear before the respondent number 3
along with the certificate. Along with the certificate copy.
8/6/2026 at 10:30 a.m. on so and so, along with a copy of this order and a copy of the repetition along with annexer. So as to enable the respondent number 3 to proceed further with the matter. Full stop. It is accordingly ordered. That's it. This order disposes of the repetition.
Item 13.
May I please, my lords? My lords, have recorded, my lords, the contours of the controversy in the last order, my lords. 22nd May, my lords.
Yes.
My lords, my lords, my learned friend, the learned senior on the other side had made a candid statement. My lords, my challenge mainly is to the vires of 16, subsection 2, subsection AA and subsection C. And my lord, the
Subsection
only
2
controversy
AA is already dealt with.
that's right, my lord. This court has allowed this in my favor, my lords. This, the ultimate, my lords, the court has held that since the supplier.
Now your challenge remains for section 16 to C.
My lords, both these aspects are now decided in my favor.
Yes. Then.
So, my lords, my writ has to be allowed in that light, my lords.
But since it is there is a prayer.
Yes.
It should go before the division bench.
That's right, my lords. That's fairly, my lords. That
heard Mr.
Puneet Agarwal, my lords.
P. Agarwal, learned counsel, should have herself moved, along with Mr. H. Vetala, learned counsel for the petitioner, and Mr. A. Jain, learned counsel on behalf of Mr. S. C. Kayal, learned senior counsel and special counsel on behalf of
Respondent number 3, 4, and 5, Lordship.
3,
4, and 5.
3, 4, and 5. Mr. H. Borua, learned counsel on behalf of Mr. B. Gogoi, learned standing counsel, Finance and Taxation Department for the respondent number 2. A.K. Dr. learned Central Government Counsel for the respondent number 1. Full stop. It is submitted by the learned counsel for the parties that in this petition. A challenges are made to the virus of section 16(2) AA and section 16(2) of the CGST Act and AGST Act have been challenged. Full stop. Para. Mr. Borua and Mr. Jain have submitted that insofar as the challenge to section 16(2) AA of the CGST Act and AGST Act, the issue has been decided by the division bench of this court in WPC number 5725/2022. On 9/12/2025, full stop, as the virus of section 22C of the CGST Act and AGST Act has been challenged in this petition, the matter. The repetition is to be considered by a division bench and not by a single bench. So, in view of the above submission made by the learned counsel for the parties, to examine the matter and thereafter to list the case before the appropriate bench.
My lords would fix a date.
No, I cannot fix a date before the division bench.
All right. I'm great.
If I can fix a date before the division bench, I can also fix a date before the Supreme Court.
No. I didn't mean that. That's grateful, my lords.
14.
May I please, Your Lordship?
Yes.
Your Lordship, I required some more time because the manager has been changed, Your Lordship.
Manager has been changed.
Yes.
To do issue notice.
Yes, Your Lordship.
Heard Mr. H.R. Ahmed, learned counsel for the petition, and Mr. M. Sharma, learned counsel for the respondent. Ujjivan Small Finance Bank for the respondent number
1, Your Lordship.
1 and 2.
Yes, sir.
Both the respondents.
Yes, sir.
Full stop. Mr. Sharma, who sought time to obtain instruction the last date of this thing, has sought further time. Has sought further time to obtain the instruction. Issue notice returnable. Let notice be issued. The notice is made returnable on so before holiday.
Yes, Your Lord.
As Mr. Sharma has appeared and accepted, no formal notice. Extra copies within 2 working days. The earlier observation.
Yes, sir.
Continue.
Yes,
Just find out whether keeping a lien of
Yes, sir.
2000.
2206. Item number 15. Might please, Your Lordship. In the last occasion, Lordship has posed a question, my lord. It's difficult for me to overcome it, it seems, my lord. Well, what I am praying, my lord, I got one judgment from the Honorable Apex Court regarding my parallel proceeding, my lord.
Where is your parallel proceeding? With two bona fide and due diligence.
But section 161 of that prescribed for rectification, my lord.
Did you?
No, I still have time because they have the power to rectify within 6 months, my lord. Their authorities have the power. I think they can rectify suo moto.
You go for that. I am not otherwise entering. I am not observing anything.
That I am not paying, my lord, but I am paying, my limited pay is that,
Whether
my
you
lord,
file a rectification application under 161 or not, it is not my concern.
my lord.
As on date, there is no bona fide any proceeding from your side against the order in original, right? And what is the there was a show cause notice and order in original.
By the
Now you have challenged this one
my lord,
without preparing an appeal.
my lord. Which one, my lord? Second one.
No, first one.
There were two. There were two
Tell
proceedings.
me, I have not gone through the facts again. I have forgotten the facts.
Yes, my lord.
Where is the order in original?
The order which I am challenging is page 89, my lord.
89.
89.
89. This is order under section 73.
73.
On what ground you are approaching this court?
That, my lord, for the same financial year, my lord, Central GST has already initiated proceeding, my lord, and they have passed the order, my lord.
So this is an appealable order.
It is an appealable order, but it is hit by section 6 of the GST Act, my lord, which says that both the orders, my lord, for same financial year.
Right. Maybe you have very good ground.
My lord,
Right.
my lord.
You may have a very good ground to appeal, but you have not appealed
Yes, my lord.
within the period of limitation.
That instruction I sought, the reason was that, my lord, this GST was cancelled.
Whatever be the reason,
Yes, my lord.
right?
Yes, my lord.
But you have not preferred the appeal within the normal period of limitation or the extended period of
Yes, my lord.
limitation.
Counted, my lord.
Now you have come with a writ petition on the ground that violation of section 6. Now, in this situation, whether a writ petition can be entertained,
That is
right? Yes, I have found out that if in the meantime, though limitation act is not applicable,
my lord.
right? If in the meantime, a civil proceeding was initiated by the assessee
My lord.
with bona fide intention and with due diligence, maybe there may be a situation to explore, but here it is not. So if you want to press for something that is for you, I'm not observing anything,
That's my,
but otherwise, I don't find.
might just limit pair matter to withdraw with liberty to available remedies, my lord.
It is up to
Remedies
you.
are available there.
I'll put everything on your mouth. I'll not say anything.
No, I'm not saying anything. Just I was paying the
Yes,
Otherwise-
Mr. Gogoi.
My lord,
Otherwise-
161, my lord, he can, my lord.
That is up to you. Thereafter, whether limitation will come in your favor or not, that is
That is a different thing.
that is a different issue.
I have time.
Right.
I have time until 18th of June, my lord. They can rectify the order, my lord.
That is up to you.
I have just found 161, my lord. Or even they have the power to do it sumo also, my lord.
Now, I am examining a matter where I have granted a stay because they have followed a rectification proceeding within time and with a bona fide manner, and which has been interpreted subsequently to GlaxoSmithKline
My lord.
in a different manner by Honorable Justice Nariman. So that may be a situation, there may be a situation to explore. But in your case, no bona fide and due diligence.
That's, I have advised my client to go for it.
That is up to you. Heard, Mr.
Lordship.
R.S. Mishra, Learned Counsel for the petition, Mr. B. Gugoi, Standing Counsel, Finance and Taxation Department for all the respondents. So Mr. Mishra has submitted that. At this stage, the petitioner is not pursuing the writ petition at this stage in order to pursue, pursue appropriate proceeding permissible under the law. Post of Mr. Gogoi. In response, Mr. Gogoi has submitted that he has no objection to the submission made by the petitioner. Post of in view of the above submission made by Mr. Mishra, Learned Counsel for the petitioner, this writ petition, that the petitioner is not pursuing this writ petition at this stage, comma, the writ petition is dismissed on withdrawal. Post of if the petitioner has any other remedy, if the petitioner has any other remedy permissible under the law, it is for the petitioner to pursue the same.
Much amendment. Item 16.
Same.
It is within time, my lord, it is the writ petition is filed within the period of limitation, my lord. What happened, my lord? They have a,
Let us see.
my lord.
31/3/2026.
First order
What
was
is the period of limitation?
3 months plus 1 month. The order was passed on my lord 33/2026, my lord.
Good enough. We have time.
Yes, my lord. Actually, there was duplication of order, my lord. That's why I kept this. There was duplication of order, my lord. Section,
That can be examined by the appellate authority.
I can also go for rectification in this case also. I can also go for rectification also, my lord.
Yes, yes.
Yes, my lord. Similar order no in this also.
Okay, with liberty to file appeal. In this case, appeal,
I can also go for because
Oh.
it is not over, my lord. I can go for rectification, my lord.
it is up to you.
My lord,
Same order,
same
same
order.
order. R.S. Mishra. And K. Jain, Learned Counsel on behalf of Mr. S. C. Kyle, Learned Senior Counsel and Special Counsel, CGST, for the respondent number
2, 3, and 4, Lord.
3 and 4. Mishra to same লিখিব, ইয়াতে join লিখিব। আৰু reserving the liberty, last লিখিব, withdrawn, reserving the liberty to the petitioner to avail appropriate remedy permissible under the law.
Election is very tough, my lord, to overcome.
Much obliged.
Item number 17.
Whatever has been done by me earlier
Lordships.
might not be correct. Few cases. Entertaining writ petition.
May please, your lordship. Lordship, this is an account freezing case. My account has been frozen since July 2024, your lordship. It's
Heard, Mr.
K. Deka, lord.
K. Deka, Learned Counsel for the petitioner. Mr. D. J. Das, Learned Central Government Counsel for the respond number 1. First of the petitioner maintains a savings bank account.
Yes, lord.
Savings bank account number so and so at Tatikata branch, Bandhan Bank, Morigaon, within bracket response number 2. Full stop. Agreed by. Full stop. The petitioner stated that the response number 2 has freezed the said bank account on the pretext that there was a suspicious credit to the extent of rupees 1,800 in the said bank account, and a complaint to that effect was received by complaint number so and so, registered on the National Cyber Crime Reporting Portal. Post of sealing the said action on the ground that the such freezing order was without notice and in violation of the procedure prescribed in section 106 Bharatiya Nagorik Surakha Honita. The petition is approached this court by the instant petition issue notice returnable on so and so as Mr. Das, number 1. No formal notice. Steps upon response number 2 by speed post. The response number 2 on appearance shall also apprise this court as to whether the bank account of the petitioner can be permitted to operate, whether the petition can be permitted to operate the bank account by keeping a lien over any disputed amount.
Your Lordship, provision item 19 is also same respondent, Your Lordship.
19.
Similar order may be found.
19.
Only the disputed amount is 1925, Your Lordship. There are two.
Moirabari. Both are Moirabari.
Same branch.
Bank will close this branch. Disputed amount.
Lordship, in this, may I kindly note that there are two complaints, and the complaint details has been given by the bank. Respondent number
1,925. Two suspicious deposits, to the extent of 1,925.
Much obliged.
Item number 18.
May I please, Your Lordship? My Lord, the petitioner availed of a loan from the SBI, my Lord, it's a car loan. And thereafter, my Lord.
No standing counsel.
No standing counsel, my Lord. Notice has to go, my Lord.
You heard Mr. D.P. Bora, counsel for the petition. So agreed by. The petitioner stated that he availed a car loan
Yes, my Lord.
from the respondent number.
Response number 3, my Lord.
Response number 3. And in the year 2013. And by under the Rin Sama scheme,
Yes, my Lord.
the petitioner settled the entire outstanding dues by paying rupees 42,277 on 1/3/2021, whereafter the loan account was treated as closed. Full stop. The petitioner has approached this court agreed by the action on the part of the respondent 3 bank in deducting an amount of rupees 1,77,415 from the savings bank account of the petitioner according to petitioner, such deduction is without any authority of law. Issue notice returnable on so and so. All are outside. Okay. Okay. Speed post. 2 working days.
22nd July. Item number 20.
Yes.
May it please your lordship. My lord, here summary of so-called was issued on 28/9/2023, my lord. Lordship will find it page 24. Thereafter, my lord, petitioner sought some time that your lordship will find it page 31.
31.
31. And 32 is the 31, my lord.
Okay.
And 32 is the status of the proceeding, my lord. Page 32
32.
is the status of the proceeding, my lord. As on, my lord, it is
Status of the proceeding.
Screenshot was taken on 19/5/2026, my lord. It's
Just a minute, just a minute. Page, you are showing me page 32.
32, my lord. The status of the proceeding, my lord.
Huh?
It is the status of the proceeding, my lord, which was initiated by DRC
Date
01.
of application. Which part? Reply date.
Now, lordship will see this proceeding was initiated on 28/9/2023
Huh.
by DRC 01. Later, lordship will find it page 24.
Page 20.
24 is the DRC 01, my lord.
DRC 01.
The lordship will find the date 28/9/2023. Lordship will find the reference number DRC, my lord. The left side, page 24. Now, lordship may see page 32. This is the proceeding, my lord, initiated by this DRC 01 status, my lord. At the first right side, lordship will see case ID, and below case ID, lordship will see status.
Status.
Just below the case ID, my lord, left side, at page 30.
Reply furnished.
Pending for order by tax
Tax
officer.
officer.
Now, my lord, this screenshot was taken on 19/5/2026. At the bottom below, lordship will see. This screenshot was taken on
19/5/2026.
recently, my lord.
Huh.
Now, my lord, petitioner submitted an application for refund on my lord, on my lord, April 2026, my lord. A refund application was submitted. When petitioner went to visit the office, inquire about the status, my lord, the officer informed the petitioner that there is a demand that your lordship will find it page 33. This is the DRC 07. There is no order, my DRC 07 is there. They informed about this DRC 07. We explored the portal, we found this, my lord, but we did not find any order, my lord, because the status was showing pending, and this DRC was not uploaded in the case record. It was uploaded separately, my lord. And this DRC lordship will find
You have to say summary of the order has been uploaded.
Yes, my lord. It is also not on this case record separately, my lord. It was not uploaded in the case status, my lord, separately, my lord. That status is showing pending, my lord, but this was uploaded separately. Petitioner was not aware of it, my lord. And then lordship will see, my lord, in the summary, my lord, there is a reference of order, my lord. Some order reference is there.
Where is that?
In page 33, my lord. That summary form DRC 07, lordship will see details of order. There is an order number.
Details of demand, details of order.
Details of order. There is an order number. Petitioner has thoroughly explored the GST portal, my lord. No order, no such order was uploaded there, my lord. We have searched each and every tab, my lord. We have not found any such order, my lord.
So you want to say that first it was summary show cause notice, followed by a summary of the order. That summary of the order was without any order
And it's not in the
under
case,
section 73.
my lord.
And moreover, the summary of the order was not uploaded in the common portal,
It was
designated
portal, but not
in a
separately, my lord.
And on the other hand, 19/5/2026, the proceeding was shown to be pending.
Lordship will see one more thing, reference of the proceeding, my lord. At page 32, my lord. Lordship will see the reference, same reference, my lord. Reply file, just below reply file, the reference number, and the lordship will see the reference number at page 24. Same, my lord.
Yes.
Well, I would like to have the instruction, my lord, because there are some, my lord, disputed facts he is placing, my lord. That is whether it has been uploaded or not, whether notice was issued or not, whether he has responded. Because in the
Did you respond?
page
I sought
32,
adjournment, my lord. I sought an adjournment.
Sought an adjournment.
Lordship,
Is it
page 32, my lord.
Page
32.
31, 31.
32, my lord.
No, his reply to so-called notice sought 30 days time
My lord.
And then lordship.
to
will say-
provide documents. Just a minute, let us keep timeline.
But my lord, in page 32, just below case ID, Lordship will see in the left hand
Ah.
side. Status, reply furnished pending for order by the tax officer.
This adjournment is treating as a reply there. I downloaded the portal, my lord. This adjournment slip is being treated as reply, my lord. And lordship will also see, my lord, of CL number.
Where is the compliance of section 75(4)? Once he ticked
Yes, hearing will have to be there. Because, yes.
75(4),
Well, I will place everything, my lord. Only 7 days time, let it be in the motion stage. It can be disposed of. If at all, my lord, these steps have not been followed as per the
Okay.
statute, then, my lord, of course, you will get a summons.
Okay, heard Mr. R.S. Mitchell, learned counsel for the petitioner, and Mr. B. Gugoi, learned standing counsel, finance and taxation department, for all the respondents. Post of para. It is a case of the petitioner that a summary show cause notice under rule 100 within bracket 2 and rule 142 1A page 24 of the CGST rules in form GST DRC 01 was issued without a show cause notice under section 73(1) of the AGST Act for the financial year 2007-2018.
Yes.
Provide reference
Okay,
number
okay.
ZD so and so last of 2 TSS. First of it is the further contention of the petitioner that the petitioner on 22/01/2024
23 to
submitted in form GST DRC 06 seeking additional 30 days time to provide the documents and a reply to the notice, and had also sought for personal hearing. Post of when the petitioner tried to find out the present status of the proceeding on 19/5/2026, that the status was shown as quote unquote reply furnished, pending order by tax officer, unquote. Post of when the petitioner inquired with the respond number
3, my lord.
3, the petitioner could learn that on 15/12/2023, a summary of the order pursuant to reference number same was shown to be uploaded in another was shown to be uploaded in the portal without there being an order under a summary of the order in form GST DRC 07 was shown to be uploaded on 15/12 dated 15/12/2023 was shown to be uploaded without there being an order under section 73 within bracket
My lord, 9.
9 or 10.
It's my lord, 9. My lord.
Nine.
Order is passed in 9.
Of the IGC Act. Post of Mr. Gogoi, and so has sought for a week's time to obtain detailed instruction in the matter. Okay, in view of the
On 8.
view of submission of Mr. Gogoi, let the case be listed again on so and so till the next date of listing, there shall not be any positive action against the petitioner in terms of the summary of the order dated 15/12/2023. One copy. Mr. Mishra shall furnish an extra copy of the writ petition along with an Excel to Mr. Gogoi to enable him to obtain instructions during the course of the day.
0806. Item number 21. Worship, this matter pertains to eviction in patta land, private patta land.
You have preferred a revenue appeal?
Yes, Lordship.
Yes, Mr.
My lord, he has already challenged that impugn order. Now his title is already been clouded. My lord, according to their pleadings, he has been evicted. My lord, once evicted in a patta land, my lord, the civil suit is the best option. If your lordship,
Yes. Huh?
in fact,
Let us, I don't know, I have last.
if your lordship come to the impugn order, page 24.
First one is page 21.
Page 24.
24.
Okay.
No,
This is
the order passed by
Prohibition
the
Ali Sarkar versus Safaruddin Nazrul Haq. Okay. Peruse the inquiry report. And for what purpose this application was?
he has been, because my lord, his name has been deleted from the midwation, my lord.
Deleted from
the midwation. He came to know, then he filed this application. It has been
his
changed.
name has been deleted.
Yes, my lord. And those who have
From land records
Yes, my lord.
pertaining to land covered by periodic patta.
Yes, my lord.
Let us read. Let me read them. And second, what is his name? Ashraful.
Before that, if your lordship comes,
Just a minute. Let me read it. Safaruddin. Ali Sarkar and Safaruddin. This man is Ashraful Haq. Second party. Okay, Ashraful Haq. Were heard. By the circle. Whatever. Relevant
the resource lives still like this.
or is from the report.
That should be said. Listen, civil suit. Safaruddin, Kumam. Safaruddin.
Legal head of unhappy decisions.
It's a better. Time. Yeah. 425.
So basically, these are patta lands.
My lord, with regard to that land, salary has already been executed, rightly or wrongly, my lord, and register instrument is there. So any relief, my lord, would be appropriate.
Right.
Because, my lord,
He has passed an order, district commissioner has passed an order.
yes, my lord, and
District commissioner, I don't know what.
from the above,
what kind of encroachment? There are two kinds of encroachment, right, Mr. Das?
yes, my lord.
One can be by, one can be of government land. one can be of patta land.
Yes.
I don't know what is
Yes, 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 yes.
the kind of
Yes.
land. I think no government land is involved.
Patta land, my lord, obviously civil remediation. But
I don't know how he has exercised the jurisdiction.
But
This page
yes,
24.
24.
It seems to be periodic patta land.
But
Seems to be periodic patta.
Yes, madam. Page
Right.
21 is the original order passed by circular. Lordship, may kindly.
No, the question is, then
Actually,
if
that
he
is a-
wants to challenge because he is a party there. If he wants to challenge this order, authority and jurisdiction of the district commissioner to pass an order of eviction in respect of periodic patta land, he can very well.
but no, that has been challenged before the land revenue. Before the
board-
commissioner of land revenue branch, my lord.
No, this order will be, this is an appellate order or what?
Yes, my lord.
This is an appellate order. So this order is appealable before Board of Revenue and he has filed an appeal.
Yes,
That is what?
Yes, my lord. I'm saying that only, my lord.
On
Yes.
that.
This order is only.
No, you are going to civil court.
No,
No. Firstly, two things. Here government land is not involved. Apparently. Or do you have any different view?
No, man.
No.
No, my.
So two private parties
Yes, my lord.
are at contest. Now, in the appellate order, page 24 is Asraful Haq. He was a party, Asraful Haq, then Safaruddin, then Rosidul Haq, and Nazrul Haq. They were parties in the appellate proceeding before the co-district commissioner regarding two plots of land or whatever, but periodic patta land. Now here we see at the end,
Yes, my lord.
right? Second parties have encroached the aforesaid land in question by force by plastic net as a boundary and two number of temporary houses and also planted banana seedling in the aforesaid plots of land. From the above observation, it has come to notice that as per registered sale deed and other relevant documents and illegal possession, second parties may be evicted from the aforesaid plots of land with the police personnel. Case is disposed of.
Yes, yes.
Whether he has jurisdiction to pass such an order.
Yes, yes.
Have you understood?
I understood.
So he has filed an revenue appeal.
Yes, that's what I'm saying.
The grievance is that is not registered.
Yes. No, my lord. That is not registered, no, my lord. It has been pending. During pendency, he has been evicted.
During pendency, he has been evicted.
Evicted. And pays 30.
If no stay order, but if that order is to be challenged, that order is to be challenged before Revenue Board.
Yeah, that's what I am submitting, my lord.
And Revenue Board finds
Yes, my lord.
that co-district commissioner
Has no power.
Has no authority and jurisdiction to pass such an order. And it was on the strength of that order,
Yes.
this eviction has been made. Situation is to be restored by the Revenue Board.
Yes, yes, yes.
Why will enter into this?
Yes, my lord. That's what I am submitting, my lord.
Let them do it. You press for an interim order before the Revenue Board.
Your Lordship, kindly allow me to make some.
Moreover, my lord, one more submission less.
Yes.
Lordship, first, I beg to make my submission, Lordship, and the impugned order, Lordship, the impugned order passed by the.
Then let us see the Janoni.
Janani at page 21. Page 19, Lordship.
Case 20. Mr. Das.
Page 19.
I read page particular one. Mr. Das.
My lord.
See.
ইয়াতে আপোনালোকক জনোৱা হয় যে তফচিলত বৰ্ণিত মাটি আপোনালোকৰ বুজনীয়া বাবে
How do you defend your officer?
গতিকে নিজে যুক্ত আপোনালোকৰ
Keraz Miadi.
Yes, ma'am.
How do you defend your officer? Tell me on this. Under what provision? He has derived the jurisdiction. It was a matter for civil court to decide.
Yes, my lord. Yes, yes.
Hmm?
Yes, yes.
Then he has passed an order, perhaps.
Yes, my lord. That is page 21, my lord.
Then
again, this order has been challenged. 611,
where is this order?
page
21,
21, my lord.
বলপূৰ্বকে উক্ত গুচৰীয়া মাটিত পলিথিন পেপাৰে দুটা চালিঘৰ সাজি বেদখল কৰা দেখা যায়। দখিল হোতে খৰিদ কৰি নামজাৰি আৰু দখল থকা বাদীক বিবাদী পক্ষই আইন বহিৰ্ভূতভাৱে চলোৱা চালিঘৰ উক্ত মাটিৰ পৰা আঁতৰৰ বাবে নিৰ্দেশ দিয়া হ'ল। Mr. Das, page 23. Then that has been affirmed.
Affirmed by the 4 district commission. It has been affirmed.
Then
he preferred a revenue appeal pending, and during pendency, he has been evicted. And FIR has also been lodged with regard to this. Page 32, my lord.
Then we'll state these two orders regarding authority and jurisdiction of the circle officer and co-district commissioner, passing order of eviction of private person from Kheraz Miadi Pattaland.
That is my contention, Lordship. Without jurisdiction, that impugn order.
But I cannot restore the situation now.
My lord.
It will take time.
But my lord,
Mr. Das, how do you defend this?
I understand, my lord. But
And
what time?
when did you file this revenue appeal?
Revenue appeal, Lordship, on
See, they are sitting over the matter. 23/12/2025.
23.
Heard Mr. A.
Islam.
Islam, learned counsel for the petition. Yes, Mr. Aforesaid, you want to say something? Mr. N. Das, learned junior government advocate Assam for the respondent number
1, 3, 4, 5, 6, 7.
567. And Mr. A. Aforesaid, learned standing counsel revenue department for the respondent number 2. First off. The petitioners, foreign number, have joined together to institute the instant writ petition, stating that they have a common cause of action, first off, on 26/9/2025, the respondent number 6 served a notice upon the petitioners stating inter alia that the petitioners had illegally constructed a polythene-made house on a plot of land measuring on two plots of land measuring 1 bigha 4 katha 5 lesa and 4 katha 12 lesa, covered by DAG number 906 and 907 under Kheraz periodic patta number 174 and 261 at village Shernagar, Agomani Revenue Circle, District Thubri, sublet plots per short, post op. After serving such notice, the respondent number 6 passed an order on which date 6/11/2025, whereby the respondent number 6 directed to evict the petitioners from the subject plots, post op. When an appeal First of sorry, an appeal was preferred before the respondent number 5 by the respondent number 8, which was wherein on 4/12/2025, the respondent 5 did not interfere with the order of the respondent number 6, order dated respondent number 6, order dated 6/11/2025 of the respondent number 6. Full stop. Agree, full stop. The petitioners have thereafter preferred an appeal under section 147, read with section 151 of the Assam Land and Revenue Regulation 1886, seeking setting aside of the order dated 6/11/2025 passed by the respondent number 6 and the order dated 4/12/2025 passed by the respondent number 5 on 23/12/2025. Agreed despite acknowledging the receipt of the appeal the Assam Board of Revenue has not, oh no, sorry,
District Commissioner.
before the respondent number 3, despite acknowledging the receipt of the appeal on 23/12/2025, the respondent number 3 has not registered the appeal and proceeded with the matter. Agreed thereby. Full stop. The petitioner have stated that after the order dated 4/12/2025 of the respondent number 5, they have been evicted from the periodic patta land forcefully by
Even Lotus sitting on fire.
at the instance of the respondent number 4. Full stop. Para Mr. Islam, learned counsel appearing for the petition has submitted that neither the respondent number 4, 3, none of the respondents, sorry, the respondent number 3 to 6 have no authority and jurisdiction to evict the petitioner from periodic patta lands, that is the subject lands, from the subject plots, as they are periodic patta lands. Full stop. The said respondents do not have any authority and jurisdiction to pass an order of eviction of private individuals, private persons like the petitioners, from the periodic patta land of the respondent number 8. And as such, entire action, and as such, the order dated so and so, it was a case number 6/11/2025 of the respondent number 6, an order dated 4/12/2025 passed by the respondent number 5 are without authority and jurisdiction and therefore illegal. So submission notice returnable on so and so.
Can I submit one thing, madam? Since this court it's only a submission, madam, has decided or has come to a finding that those 2 orders were illegal and authorized.
I have recorded this submission.
Submission, my lord. Otherwise,
I'm saying this.
stay, my lord, but otherwise, if your lordship come at this point, it's an illegal. It will have a bearing on the revenue appeal, my lord. My submission is at present, my lord.
What does Whirlpool says? When an order is passed without jurisdiction, palpably, writ petition is maintainable. Even if there is a statutory remedy.
Yes, 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 yes.
I am keeping that
Yes.
dictum in mind.
Only-
So do not make submission unnecessarily. When it is palpably clear,
I'm sorry. I understand.
issue notice, returnable on so and so. As so and so has appeared accepted. 1 to 7 we will steps upon respond number 4. Having privacy satisfied that the respond number, neither the respond number 6 and the respond number 5 and the respond number 6 have no authority and jurisdiction to pass an order of eviction of private persons like the petitioners from the periodic patterland of the respond number 8. It is ordered in the interim that the operation of the impugn order 6/11/2025 and
4/12.
The order dated 4/12/2025. Annexer contour hobo, Annexer 2 and second tour hobo, Annexer 2A shall remain suspended until further orders.
2007, 28th July.
Copies, ma'am.
I am obliged.
Already.
Sir, copies. Apply.
22, item 22. May I please?
Yes.
The matter regarding the remission of the settlement amount. In this case, my lord, by order dated 17/8/2025, the launch charge namely my lord, Pokraranga to Dhubri launch ghat evening was settled for the period of 2025-26. That is from my lord 1/8/2025 to 36 of 2026. My lord. During the my lord, this period, due to my lord, erosion of the river bank, the ghat in person was shifted from one place to another. Moreover, my lord, due to my lord low water level, the launch my lord could not operate my lord smoothly, and he has suffered loss, my lord. And the matter was my lord represented before the local considerers institutions, but no order was passed. Finally, my lord, he filed a representation before the my lord principal secretary, that is page my lord 29, 1/21/4/2026, and that is still pending for consideration.
Yes, is it a bench 5 matter?
That's
Or you want similar order?
Yes, my lord. But
Similar order.
But
Page
lordship,
32.
32 million.
but lordship now, there is no any post in the principal secretary to the government of Assam. Now it's additional chief secretary to the government
If
of
that
Assam.
be so, my lord, I will file my lord fresh application, my lord, before the additional secretary.
Additional chief secretary.
Additional
Lordship.
Additional chief secretary.
To the government of Assam, Panchayat and Rural Development Department. No, there, no,
To the government of Assam.
lordship,
Panchayat and Rural Development.
department. No.
So he has to file a fresh application.
Well,
Okay, then this follows.
only submission before last.
Miss N. Bora.
Lordship.
I will file within 1 week. That will be considered within 15 days.
Okay, within 10 days.
Yes,
Lordship.
obliged.
Applies.
Page 32 for separate. File them.
May I please, Lordship? In this case, my lord, the husband of the petitioner died during the course of election duty, my lord. And the respondent authority also sanctioned the amount of.
Financial sanction.
has been made, my lord, last annexure, my lord. Page
Government
14.
Commissioner, wants to the last annexure.
Page 40, my lord.
Last in order, Yes. Concept and rural development.
Yes.
Lordship will take instructions.
Get instruction, no point giving issuing notice already.
Lordship.
Already, everything has been processed. It is lying pending at the
Lordship.
office of the additional chief secretary.
Yes.
First, Mr. W. Rahman Learned, counsel for the petitioner, and Ms. N. Bora Learned, additional Learned standing counsel. Culture and Rural Development Department for the respondent number 1 and 2. And Mr. H. Borua, Learned Junior Government, Learned Counsel on behalf of Mr. B. Gogoi, Learned Standing Counsel, Finance Department for the respondent number 3, and Mr. H. Sharma, Learned Additional Senior Government Advocate for the respondent number 4. Full stop. Para, the petitioner is the wife of late Alauddin Ahmed, who was appointed as a presiding officer during Panchayat election
My lord.
2017-18. Full stop. As a result of the accident occurred on 10/12/2018, when the petitioner's husband was returning with another person after Panchayat election duty, he died, succumbing to the injuries sustained. Full stop. As Alauddin Sarkar died during election duty, an application was prepared seeking release of ex gratia payment. Full stop. The matter of ex gratia payment was processed at different levels, and finally on 30/12/2025, the respondent number 2 forwarded the matter to the respondent number 1 to accord financial sanction for an amount of rupees 10 lakh in favor of the petitioner towards ex gratia pursuant to a direction made in an order dated 7/6/2024, passed in a writ petition WPC number 110/2021, prepared by the petitioner. As the matter of according financial sanction is presently lying before the respondent number 1 and is lying before respondent number 1 since 30/12/2025 without any discernible steps to release to disburse the said amount of petition is before this court by the instant writ petition. Ms. Bora Learned, Standing Counsel, Panchayat and Rural Development Department, representing the respondent number 1 and 2, has sought for a week's time to obtain up-to-date instruction in the matter as to whether any financing section has been granted or not, whether financing sanction was ex gratia has been accorded or not, and if not, within what time the financing sanction is likely to be accorded. As sought for by Ms. Bora, lists the case on so and so. As a copy, Mr. Rahman, learned counsel for the petitioner, shall furnish a copy of the petition along with annexure to Ms. Bora within 2 working days.
10 June 10/06. For admission, item number 24.
Mr. Mohanta, will convert it,
But my lord, my lord, aspect is only that, my lord, I have been informed that the respondent number 1 is expired, my lord, but the other respondent number 1 next son, is a respondent number 2 is here, but he is.
That will be decided by the.
Yes,
Yes, madam.
And education.
Heard Mr. P. Mohanto, learned counsel for the petitioners, and Miss B. Deka, learned standing counsel, Elementary Education Department, Government of Assam, for the respondent number 4 and 5. Post of Para. The petitioners have preferred the present litigation under Article 226 of the Constitution of India to assail a judgment, an order dated 8/5/2023, passed by the learned additional session judge number 2, Nagaon, in special land grabbing case number 05/2018. Full stop. The judgment and order dated 8/5/2023 has been passed by the learned additional session judge number 2, Nagaon. As special tribunal under the provisions of the land Assam Special Tribunal within bracket land grabbing under the provisions of the Assam Land Grabbing within bracket Prohibition Act, 2010, and by the said judgment and order dated so and so, it has decided on the civil liability. Full stop. Para, when notice of notice of motion was issued on 20/09/2023, comma, this court had kept the maintainability of the writ petition open with an observation that the said question and the maintainability issue point would be gone into at the stage of admission hearing. Post of para. In a judgment and order dated 27/2/2024, passed in a writ petition WPC number 558/2024. It has been held that the special tribunal, when you look at land grabbing, is the court of district and session judge, as well as the additional district and session judge, comma, which are pre-existing judicial authorities. Full stop. The special tribunal in the civil proceeding, comma, can decide the civil liability, and in the criminal proceeding, comma, can decide the criminal liability. Full stop. Does, comma, for all intents and purposes, comma, the special tribunal is to be deemed to be a civil court. The adjudication as regards civil liability, it has been held that the adjudication as regards civil liability lies not in a particular presiding judge of a particular civil court, but to the court of the district and session judge, which includes the additional district and session judge. Full stop. Therefore, the judgment and order dated so and so. Therefore, comma, A challenge to a judgment, an order of the special tribunal land grabbing is not maintainable in the writ jurisdiction under Article 226 of the Constitution by filing a petition styled as a writ petition. It has been held that such an order, such a judgment and order of the land grabbing tribunal, a challenge to such an order, judgment and order of the land grabbing tribunal must ordinarily proceed only under Article 227 of the Constitution of India and not under Article 226 of the Constitution of India. Full stop. Para. Mr. Mohanto, learned counsel for the petitioner, has submitted that since the instant petition was filed in 2023 and a period of 3 years has elapsed in the meantime, the present petition may be converted to a petition under Article 227 of the Constitution of India. Full stop. Para. As this court has already held that a petition to challenge a judgment in order of the special tribunal land grabbing constituted under the Land Grabbing Act, deciding the civil liability can only be maintainable in a petition under Article 227 of the Constitution of India and not under Article 226 of the Constitution of India. And such a petition is to be registered as a civil revision petition within the CRT ART 227 bracket close comma. The prayer is found just and in the interest of justice. The registry is therefore, to register this petition accordingly and to list the petition thereafter, before the appropriate ends.
227 was mentioned in this case. My petition 226 along with 227.
It has been registered as.
Yes, but 227 mentioned. I was in.
And I do not have the register, roster.
Yes, ma'am.
Of 227.
Yes.
So I cannot exercise that jurisdiction.
Must.
Item 26. May I please, your lordship, kindly matter may take up after a while. My senior,
After a while today, sir.
my
It
senior
is
is
not
on next.
possible. Maybe some other day.
There was a direction on the last occasion, lordship, to make an endeavor to produce the original award copy.
Yes.
If my land has got the copy, lordship, I may be provided with the copy.
Let us, okay, then come. It is available. Other something.
Item number 28.
Your Lordship, I am appearing on behalf of engaged counsel Mr. Jack Khalid, who is currently indisposed, Lordship.
Indisposed. Indisposed.
Due to some medical urgency.
Yes, Mr.
Lordship.
Das, medical emergency.
Okay.
Of course.
Miss
F. Farid, Lordship.
F. Farid, learned counsel, appearing for the petitioners, has submitted that Mr. Jade Khalid, learned counsel, who leads her in this case, is indisposed. And on the ground, Ms. So-and-so has sought for listing of the case on another date, post of Mr. N. Das, learned junior government advocate Assam, for the respond number 1, 3, and 4, and Ms.
3, 4.
N. Bordoloi, standing counsel Revenue Department for the respondent number 2, who are present, have submitted that in view of the grounds cited for adjournment, they have no objection to the prayer, post of. In view of the grounds cited, the prayer is allowed, list the case on so-and-so, the interim order passed earlier shall continue till the next date of listing.
1506. Item 29.
My pleasure, Lordship. Lordship, due to my personal difficulty, Lordship may kindly adjourn the matter for 1 week, Lordship.
On the prayer of Mr.
Yes.
Zayas Ahmed, learned counsel for the petitioner, list the case after a week. Who is present?
I'm-
Miss M. Borman. One. Junior government is present.
Also appeared, Lordship.
Huh?
Who also appeared.
Who two? Who is two? Oh, don't implead.
Family court was responded.
No, don't implead family court in a writ proceeding. Court has already directed to strike off.
Lordship.
You don't know the procedure of writ petition. Don't implead the court as any of the respondents.
Supplementary list, items 37 to 40.
Yes.
My lord, I'm appearing in relating to settlement of market by municipal board, Goalpara Municipal Board, my lord. There are 4 writ petitions in which I am appearing for 3 of the petitioners.
In the other one, Mr. Das.
Yes, my lord.
Okay. Notice has been issued. Your writ petition pleading is complete.
Yes, my lord.
What about the item number 40?
My lord,
You are a respondent there.
I am respondent, my lord. The board has in principle taken a decision to cancel the allotment.
In your favor?
In my favor, and again of the respondents in my writ petition, my lord. That order has been challenged by filing this writ petition, my lord. And my reply affidavit filed in my case will cover the case, my lord.
Yes, who is the municipal board?
UDAS appears, my lord.
UDAS.
records were-
Miss UDAS. Sound item number 40.
Name, sir. What's that?
So basically, it is a decision of the municipal board.
Yes, my lord.
Records were called for on the last occasion.
If the council is absent, how can the record?
Lordship.
Okay, this is the first date for the item number 40.
Lordship. After
Concern records available. The council is not available, how can the record be available?
My lord will fix it, my lord, otherwise lordship will be.
Each of property for the petitioners in 37, 38, 39. And Mr. D. Das, learned counsel for the private respondent in 37. And for the petitioners in 40 are present. In this writ petitions, the subject matter of challenge is a decision of the respondent municipal board for allotment of shop houses. Full stop. On the previous date of listing, in the order dated 34/2026, passed in item 40, the learned council appearing for the respondent municipal board was asked to keep the concerned records available on the next date of listing, 29/5/2026. Ms. Udas, learned counsel for the respondent municipal board is found absent today on call. And no counter affidavit has been filed on behalf of the respondent municipal board in WPC number 2256/2026 till date. Post of, as the records are directed. No, as the respondent number, as the line counsel for the respondent municipal board is found absent today on call, let the cases be listed on so and so.
On a hearing date.
On which date? On which? Don't interrupt, sir. On which date the learned counsel for the respondent board shall keep the records, relevant records available for perusal of the court. Give it date.
21st July.
I'm obliged. Deeply.
There is interim orders, Lordship, in 37.
Item 41.
Wherever passed earlier shall continue till then.
No.
Ask your son. Yes.
Slight difference is there, otherwise, my lord, lordship may kindly see the so cause at page 38. It has been issued under Rule 22(1), not under 21A.
Hmm? The provisions are a bit inconsistent.
Yes, that's why under 22(3) also we can do, my lord. Lordship will see for cancellation of, if lordship will see the GST in that case, my lord.
Okay, let us see page 38.
My lord,
That's GST Act.
the rule, my lord. এইখন ইটো কপি কৰিব লাগিব সেকেন্ডলি এনেকা আৰু এখন যে আছে মই কৈছিলো না
Yes, Rule 10A.
It says, my lord, after a certificate of registration in form so and so has been made available on the common portal and a goods and service tax
After
identification number
certificate
has
of
been
registration
assigned,
in so and so is made
the
available
registered person except
on the
those who
common
have been
portal.
granted registration under Rule 12 or as the case may be. Rule 16 shall as soon as may be, but not later than 45 days from the date of grant of registration or date on which the return required.
You are
Under-
supposed to provide the bank details.
Yes.
10A.
10A, yes.
Shall within a period of 30 days from the date of grant of
Good,
registration
good,
or
good,
before
good.
furnishing the details of outward supplies of goods and services or both on the furnishing from the basis of bank details on the common portal that he has paid. Now the proceeding is to be initiated under
Well, Rule 21,
Section 29.
21.
Section 21, 9, Section 29.
No, 20, yes, Section 29 is there, but my lord, the procedure has been laid out in Rule.
Cancellation of registration may on his own motion so and so in case of death. 29B. 29(2).
My lord. Yes.
A. Now 20, Rule 21.
Now Rule 21. D says, my lord, violates the provision of Rule 10A. Registration to be cancelled in certain cases. The registration granted to a person is liable to be cancelled if the said person violates the provision of Rule 10A.
Now Rule 21 capital A.
My lord.
Then sub-rule 2A.
Yes, ma'am.
Then B.
Yes, ma'am.
That is why I am saying that it is not conceivable. These two
Yes,
provisions.
my lord, lordship will see 22 again. 22 says, my lord, cancellation of registration. Rule 22. And this has been followed. Where, my lord, it is 7 days.
But 21A, if you
21 to
want to reconcile both,
my lord,
then 2A of 21A, B, where there is a contravention of the provision of Rule 10A by the registered person.
my lord.
Then first you have to suspend it.
Yes, ma'am.
Then he has to be provided with an opportunity of 30 days.
My lord.
That is a problem. That is why I am saying that it is not reconcilable. Both the.
Here probably suspension part is not there, directly cancel.
But it says first you have to suspend, give an opportunity of 30 days to him
Lordship.
to explain.
But
Thereafter, you can proceed 21A comes before Rule 22.
My lord.
That is why court has intervened, actually.
Lordship. No, 22 Lordship will see, says otherwise. My lord, if you go by.
That is why I am saying it is not reconcilable. Both
Yes.
are not fit into one another.
Yes, though the amendment has been brought in, my lord, 22 has.
Yes, that is why we are saying that
My lord.
something is missing.
My lord.
It says 22 says 7 days, 21 section
But
rule
it said
21A.
Within is the word, my lord. Within a period of 30 days, not 30 days, my lord. It may
But where
be.
is the opportunity?
Oh.
That is not reconcilable. That is why it has been interpreted.
But
Yes, what prejudice is going to be caused to the state?
But one
I
thing, my
don't
lord,
think
that-
any prejudice is.
My lord, in the earlier order, no liberty was granted to us. But that liberty may be granted to us, my lord, issued a notice under the proper provision of the act by giving that appropriate time. If that is granted, then.
It is something
Yes,
which
Lordship.
revenue, Mr. Gogoi, I can understand.
Lordship.
But this is only.
Yes, otherwise, my lord, the order passed by the, my lord, coordinate bench of.
And this is also.
Yes.
He has annexed this one also.
Yes, in fact, 57, my lord.
Yes.
My lord.
Well, dispose of this. Get it appealed.
My lord.
Get it appealed. Dispose of. P. Gogoi, S.K. Saha. Petitioner, P. Gogoi, has standing counsel finance and taxation department for all the respondents.
Yes, all the respondents.
Time being matter, item 26.
Ah.
My lord, kindly matter may take up some other time. He's still on legs.
Okay, J. Kolka petitioner. R.K. Talukdar.
Yes, Lord. For one.
Standing counsel and HI District 1 and 2. Who is there? N. Bodulu, revenue. And Mr.
Pika Kutel.
Okay, D. Gusami, oh sorry.
On behalf of
Mr. N. Das. Junior government advocate. Okay. Mr. P. Kakoti.
Yes.
Learned, so Mr. P. Kakoti, learned counsel appearing for the respondent 4 and 5. Has sought listing of the case on another date. Okay, M. Bodulu. Has sought for list the case on service.
So, Lordship, respondent will produce a copy of the award.
It is already there in the order.
Obliged. 15. Lordship. Obliged. For orders, item 32. Item number 32.
Where has Mr. Gogoi? Gogoi has gone. Mr. B. Gogoi? As Mr. B. Gogoi and additional advocate general Assam is not present today, there is the case on sales. Video. Okay, I will pass the order on
That clarification has been sought for by the registry, my lord, to whom it is to be given.
Okay, I'll not go through it right now because those other one I have posted.
There is a note,
another,
it is
another
very clear. There is a note, it is very clear.
Okay, I'll not read today.
Lordship.
I'll list the case on sales. Not like Mr. B. Gogoi, right? Mr. B. Gogoi present, click you.
1006. 33. Item number 33.
Well,
2016.
Lordship. The fresh proposal has been already submitted by the chief engineer to the government, no?
What is the direction?
Page number 10, my lord.
Contractual use,
Contractual dues as per
Tamsir Ali.
as per transfer early, yes, chronological order in accordance with the ratio of the full bench decision in terms early.
And your dues pertain to which year? Definitely before 2012.
Page number 9, my lord.
This code on civil director declared 1999.
Lordship. But in fact, earlier proposal were given, but there is some defect. On last occasion, I apprised the honorable court that chief engineer has directed the executive engineer to submit fresh proposal. Now that has come and the chief engineer has already submitted it to the department, my lord.
So what order is required to be passed today?
But the department ultimately proposal for release of fund.
Ensure payment as per chronological order
Lordship.
in accordance with the ratio. Now what do you say? We can postpone it by
But the digitally
period as you desire, so that
digitally signed copy has well, that signature has not come. I'm giving
a
a free.
question will not raise there perhaps. Direction is to ensure payment. Now 14 years since 2012 and the liability is of 1999. So get the next instruction.
Lordship.
Otherwise, this 2016 condemned petition.
Lordship. And my lord, interest at the rate of 12%, that is also
26 lakh sanction. Well, they have submitted proposal
the
for
proposal has
sanction.
been said. More than the principal.
Heard Mr. H.K. Das
H.K. Sharma.
Sarma, learned counsel for the petitioner, and Mr. D. Nath, learned standing counsel PWD for the respondent number for standing counsel PWD. Post of Mr. Nath has placed a unsigned copy.
No, my lord, it is signed. Kindly take the next copy, my lord. Subsequently, I have given another copy, my lord. Kindly take. Well, it is digitally signed. Signed is at below.
Has placed a letter.
At bottom left.
Letter number 395132.
Dated 25/5/26.
Dated 25/5/2026 of the Chief Engineer PWD within bracket Roads, Assam, whereby a demand proposal for release of fund against the present contempt petition, arising out of WPC number 1651/2011, for an amount of rupees 26.33654 lakhs has been submitted to the Public Works Department, Roads, bracket, within bracket, budget branch. Poster. Taking note of the direction made in the order dated 30/8/2012, passed in WPC number 1651/2011, Mr. Nath shall obtain further instruction as regards sanction of the demand proposal on the next set of listing. Give it after vacation.
Mala.
Place the case on.
2007. The papers may be kept on record.
The documents, the letter number, no, sorry, the copy of the letter number so and so, dated so and so, along with the documents placed by Mr. Nath is to be kept with the case record.
Much. Item 34.
Why it has come? Response number 1.
Well, I am appearing for 1 and 2, my lord.
Okay. Now, your affidavit?
My lord, during this week, my lord, it has gone for vetting, my lord.
Okay. Mr. P.R. Sharma, Learned Counsel for the petitioner is present. Mr. P. Hazarika, Learned Counsel appearing for the response number 1 and 2 has submitted that the draft affidavit on behalf of the response number 1 and 2 has already been prepared and sent for vetting. He has sought for listing of the case after 2 weeks in order to file the affidavit in the meantime.
My lord.
List the case on such.
19th. My lord. Obliged. Obliged, man.
Item 35.
Lordship, Lordship, with respect, Lordship, the Honorable Court please to in a Lordship. On this
Louder.
This Honorable Court in this much arrest Lordship, please to pass the Lordship 4/5/2026 Lordship. Kindly find Lordship page 18 Lordship.
Page 80.
1/8 Lordship.
1/8.
Little bit modification Lordship. Yeah, here it goes. And the relevant part is Lordship. I'm sorry. Just mention. Yes.
Yes, now what?
Page 19 Lordship.
This is
Fresh for the
review petition.
Yes, Lordship. Yes.
On what ground?
Lordship, the concern is the fresh cause of action, Lordship.
Fresh cause of action.
Yes, Lordship.
Okay, what
Lordship,
fresh cause
so
of?
whatever, Lordship, Order 1, Rule 3 is a clear defined, Lordship. The CPC, Lordship.
Order 1, Rule 3. What does it define?
Rejoinder and the rejoinder, Lordship. The CPC, Lordship, can define, Lordship, Order 1, Rule 3, Lordship. And the Order 9, Lordship.
Order 1,
Rule 9, Lordship.
Rule 9.
Yes, Lordship. Yeah. You can define Lordship. Can define Lordship.
Reasoning ground.
So, Lordship, with respect, Lordship, to previous writ petition, the petitioner did not include the 3-number respondent, Lordship. The Chief Engineer of the Water Resource Department, Executive Engineer, and Lordship, Finance Department, Lordship.
What is section 114 of the CPC? And order 47.
47.
Rule 1 CPC.
The review, Lordship, the sufficient ground, Lordship. So, Lordship, we do respect, Lordship, the order 23, Rule 1, subclause 3 and subclause B, Lordship, can be defined, Lordship, without party.
Non-implement of the party in the which writ petition? That writ petition dismissed by me or writ petition dismissed by Honorable Justice Medhi?
So,
in which writ petition?
Lordship, double two.
In which writ petition? The writ petition dismissed by Honorable Justice Medhi or the writ petition dismissed by this court? This court. There you did not implement the necessary parties.
No, Lordship, so concern is, Lordship, the previous writ petition, Lordship, liberty was granted by the Honorable
For
Justice.
fresh cause of action.
Yes.
No, I have held that there is no fresh cause of action. By way of representation, it cannot be said that a fresh cause of action has arisen. Now you want to say that non-implementment of the party is a fresh cause of action. So this ground, have you heard section 11?
Yes, Lordship.
Explanation.
So, Lordship, we do-
Subsection 4. Please read. CPC. Explanation 4. That would come within it.
Pardon me, Lordship, this section, Lordship.
Section 11. Explanation 4. You better file appeal.
Res judicata, Lordship.
Hard, constructive res judicata.
So, Lordship, order 20, Lordship, we do respect, Lordship. Lordship, order 23, rule.
What is the ground for review?
Lordship, page 13, Lordship.
Page 13.
So I have raised this query, Lordship, in the order 1, 2, 3, and 4, Lordship.
I am not passing the original order. Original order has been passed by a coordinate bench. There it observed a fresh cause of action.
Yes.
Now we are limited to fresh cause of action. I dismiss the writ petition because I find that there was no fresh cause of action. By submitting a representation, one cannot say that a fresh cause of action has arisen. That is what I think I have observed already. Now you are saying that a similar situated person has been granted relief. That is not the scope of the second writ petition.
Lordship, I'm not saying that, Lordship, but my
Then
concern is.
third ground, no. Then
Lordship, I have raised this query, order 23.
for first ground, order 1, rule 3 and 9. Okay.
Is a misjoined and non.
Then order 23, rule 1, 3B. What is this?
So let us see.
Mr. Das has taken so many ground. Order 23. Mr. Das is
without
making the court read provisions which this court has never read earlier.
So may I read, Lordship, this part, Lordship? Order 23. 1B, Lordship.
Order 23.
B, Lordship, subclause B, Lordship. Kindly find, Lordship.
No, liberty is granted. Liberty is granted only to the limited point that fresh cause of action.
So, Lordship,
Ground 1, non-implementment is not a fresh cause of action. And if you read Sarguja Transport, shall I quote? I did not quote on the earlier date because I thought that it is not required.
So one judgment is clearly defined, Lordship.
Hard, Mr. R.C. Das.
One judgment, Lordship, passed this honorable court, Lordship. The Pushpendranath Bora case, Lordship, we do respect, Lordship. So hence clear, Lordship, that without implicit the party, Lordship, so is automatically dismiss this petition, Lordship. The party should be recalled, Lordship. So otherwise it will be.
If Mr. Ratan Das does not implicit the parties, court will request, please implicit the parties. Thereafter, I will dismiss the petition.
Kindly find the one judgment, Lordship. These are not the court has. Para number 6, very small paragraph, Lordship. We do respect, Lordship. This honorable court has passed this order, Lordship. Is a middle part, Lordship. Para number 6, Lordship. May I read, Lordship? Defined by the Order 23 Rule 1 subclause 3B, Lordship. Is a formal defect defined, Lordship. The preponderance judicial pronounce that formal defects has to be the understood. To respect, Lordship, the next is Lordship, para number 3, Lordship, the third line, Lordship. Empower the court, allow the withdrawal of a suit with liberty to file a fresh for the same matters, Lordship.
Basically, it is page 5. After all this discussion, what is apparent from the above is that in a given case,
yes, Lordship,
plaintiff may be permitted to withdraw the suit with liberty to file afresh only if the defects are found to be of form and not of substance. That was, this situation would have been present when the order was passed by Honorable Justice Medhi by the coordinate bench. That situation was not present when this court dismissed the writ petition.
So, Lordship, we could respect, Lordship,
Hard.
Lordship, it will
And judgment has to be read in full, not in part.
Lordship, kindly find my additional affidavit, Lordship. Just kindly find, Lordship, the piece 114, Lordship. Kindly find, Lordship.
You have defaulted when the writ petition was withdrawn.
So I
with the rider
so the
that only in the event of a new cause of action, it will be permitted to file a writ petition afresh.
So
on that limited ground, Mr. Das.
So, Lordship, with due respect, let me say, Lordship, only for 1 minute, Lordship. So, Lordship, the Honorable Coordinate Bench, Lordship, so I have placed that particular Order 23 Rule 1.
What I cannot sit over the decision of the Honorable a Coordinate Bench.
In regard to, Lordship, the finance was not party, Lordship. Another two.
That you go and agitate before that court filing phase 1.
Lordship, in my additional affidavit, kindly find, Lordship, please 114, Lordship. Lordship, title page is a page number, relevant part is page 1118, Lordship. 118, Lordship. 118, Lordship. So here in Lordship, only the 4 number respondent is here, Lordship. So there should have to the chief engineer of the
Mr. Das. This is too much.
For respondents has not been
Heard.
Lordship. So issue is very simple, Lordship. On that way, Lordship, kindly allow, Lordship.
RC Das,
So this is
direct
modify,
counsel for
Lordship.
the petitioner. Revenue, aforesaid. 1 and 2. Emborman.
3 only.
3. Posto. The present review petition is preferred by the petitioner seeking review of an order you have done the damage on Mr. Das to yourself on 17/3/2026.
Yes, Lordship.
Right. I cannot restore the damage. Seeking review of an order dated 4/5/2026. Passed in a petition 2260/2026. Post. Para, in order to appreciate the issue, in order to examine the ground of review, pleaded in this review petition, a reference has to be made to an order dated
4/5/2026. Annex 1.
(17/3/2026) passed by a coordinate bench of this court in another writ petition, WPC number 3097/2024, also preferred by the review petitioner earlier to WPC number 2260/2026. Post of. The writ petition WPC number 3097/2026 in the following order was passed on 17/3/2026, page 25, Puratu. After dismissal of the writ petition on withdrawal, subject to the rider that the petitioner will be at liberty only in the event of a fresh cause of action, the review petitioner herein, as the writ petitioner had preferred the writ petition WPC number 2260/2026. Post. After tracing the inner writ petition WPC number 2260/2026, the review petition herein, as the writ petitioner therein had projected that after the order dated 17/3/2026, the petitioner had preferred a representation on 23/6/2026, and the same had given rise to a fresh cause of action. Postcom. After tracing the history of litigation pursued by the petitioner, no, after tracing the list, after examining the nature of liberty granted by the order dated 7/3/2026 by the coordinate bench and taking a view that filing of the representation dated 23/3/2026 would not give rise to a fresh cause of action. The writ petition was dismissed by the order dated 4/5/2026, the review of which has been sought for by the present writ petition. Full stop. In the grounds of review
Lordship, I'm sorry for this.
pleaded in the writ petition,
Lordship, with due respect, Lordship, I'm sorry for this, Lordship. With due respect, Lordship. Lordship, I'm sorry for that, Lordship. I may allow Lordship only for.
now it will entail cost.
Lordship, for a moment.
It will entail cost now.
I'm sorry for that.
It is stated that the court has erred in law under Order 1, Rule 3 and Rule 9 of the Code of Civil Procedure, 1908, on the point of misjoinder and non-joinder of parties, as a number of necessary parties were not impleaded as party respondents in the subsequent writ petition WPC number 2260/2026. That is your ground in support and the same.
No, Lordship, previous writ petition did not implicate the party, Lordship.
Either in the writ petition WPC number so and so, and also in the subsequent writ petition WPC number so and so.
Subsequently, writ petition I have implicate, Lordship. Subsequent 2260 I have implicate, Lordship.
Then how can I sit over the court bench's decision? You go and seek review in that court.
Yes, Lordship.
I cannot. I dismissed on the ground that fresh cause of action has not. In support of his submission, Mr. Das, learned counsel for the review petition, has referred to a decision in Puspendranath Bora versus Lolit Chandra Bora 2015. Year 2015, Gauhati 2041. First step. In the decision in Puspendranath Bora Supra, the Honorable Court, after examining the provisions of the expression, comma, quote unquote, sufficient grounds appearing in clause 3 of Order 23, Rule 1 of the CPC, comma, has observed that a plaintiff may be permitted to withdraw the suit with liberty to file afresh only if, comma, the defects are found to be of form and not of substance. Full stop. Para. On a query, Mr. Das has explained that non-impediment, non-joinder of necessary party had occurred in the the defect on the part of the review petitioner as had occurred when he preferred the writ petition WPC number 3097/2024 and such defect did not occur in WPC number 2260/2026. Right? Full stop. A defect, even if it is assumed, accepted that the contention of the petitioner, review petition is correct, comma, this court, and the defect occurred in WPC number so and so, WPC number 3097 2024, not in WPC number 2260/2026, comma, this court, which did not pass the order dated 17/3/2026 in WPC number 3097/2024, cannot review the order dated 7/3/2026 on the ground of formal defect. Full stop. It is in the order, it is relevant to mention that in the order dated 4/5/2026 passed in 2260/2026, comma, this court has held that the representation dated 23/3/2026 could not have given rise to a new cause of action. Full stop. After the order of dismissal on withdrawal with the rider in 17/3/2026, comma, this court does not find any merit to entertain this writ petition, as the writ petition, review petition, the review petition is being bereft of merit. As the grounds of review, ground on which review is sought for is not a permissible one under Section 114, read with Order 47, Rule 1 of the CPC, comma, which are made applicable also in a writ petition. Full stop. The review petition is accordingly dismissed. There shall be, however, no order as to cost. Yes, what is the Mr. Porvunia's case?
Item number 45.
May I please, your lordships, 45, 46.
Yes, any objection, Mr.
No, lordship.
Taludar?
No, lordship.
How much time?
7 days, sir.
7 days. Earlier given 10 days, now 7 days.
10 days?
10 days.
Lordship.
10 days.
Obliged. Both
Next one?
lordship.
10 days.
Common order. In both the case.
FU
order is
Borbuya
common.
for the applicant. Then please write the names. Yes, and Mr. Das, you have any objection?
Listen, my lord, only that should not be recorded, my lord. Verbally objected.
Transport, Mr. R.K. Talvija.
Yes, Lordship. NHIDCL
NHIDCL 1,
and 6.
6. Revenue and disaster A. Bodasaiji 2. Panchayat. No Panchayat. Mr. Dina, you are for? 7 and 8. Standing outside PWD. State Council and us. 4 and 5.
4 and 5.
Item number 2.
In item 46, I am appearing for NHIDCL, respond number 6.
Okay, 1 and 6.
1 and 6.
1 and 6, same. Any Panchayat Council? No. Okay. 10 days.
Obliged.
Mr. Borge, just write down the names for the parties
Lordship.
so that I don't get confused. In a piece of paper,
Lordship.
the name of the councils.
Lordship.
Respondent council.
Respondent council. Lordship.
Lordship, item number 36, there is an urgency in the matter, Lordship.
Not today, madam.
Lordship, it's only for service.
So what kind of urgency in a service report?
Lordship, the urgency is this, that the petitioner was awarded.
Madam, I am already over time.
Lordship,
Due to paucity of time, use the case.
last